Audio.
Hello, how are you?
If your lordship recollects, Patik Shetty, it was a matter.
Huh.
He's about to get married. His name appears every single time is,
Masking.
yes, my lords.
Lordships, may I request that
With your
some
lordship.
matter to be taken up? There are over a dozen new matters filed. The interim orders is to be extended to them as well. Any date?
No, the new matters also come before me.
Yes, my lord.
Who is it? That's a little. New matters may
Your
not come before me. One minute, sir.
We have connected all the new matters to the matters your lordships were hearing.
Let's see. Give it.
130 proceedings, my lord. Earlier, this court had disposed the criminal petitions that were filed by the complainant and the respondent. Now, I wanted to examine witness in 130 proceedings, but the trial court has rejected the application. Afternoon, my lord.
Okay. ಯಾವತ್ತಿದೆ ಅಲ್ಲಿ?
ನಿನ್ನೆ ಇತ್ತು, ನಿನ್ನೆ ಡೇಟ್ ಹೋಗಿದೆ. ನೀವು ನಾಳೆ
ನಾಳೆ
ಪ್ಲೀಸ್ ಬ್ಲೇಸ್.
Yes.
With your lordships, kind leave. In a criminal revision petition 1140 of 2023, it is a part-head matter from last 2 years. It is not getting listed. The respondent, pardon me, negotiable arising out of 138 proceedings pertaining to MLA.
Special court matter.
As MLA, yes, madam. Yes, madam.
We'll post it.
Kindly fix that date, my lord, because the respondent is
Next
not
Friday.
well.
Next Friday. Yes.
Yes, madam. Much obliged.
One mentioning, my lord, serial number 17
The list, madam.
for the respondent.
One second.
Senior counsel is not available today. Also, I have posted not to post any matters for today and
ಅದು
tomorrow.
ನಡೆಯಲ್ಲ.
Non-posting.
Not to post memo ಎಲ್ಲ. Those days are over. You tell me what do you want.
Kindly have it next week, my lord. Also inform the other council, my lord.
That's okay. Make that submission.
My lord, any day after 5, my lord, November 5.
5 o'clock.
5. No.
All right. Now list on 6th November.
Oblige.
Grateful. At the request of the council appearing for the K-Waiter respondent number 4. Yes. Now who's going to start?
For the readings, number 1.
That's a word before my friend Mr. Chandyok starts, my lord.
Yes, sir.
I was informed by my friends at the CCI, my lord, that the learned attorney is on his way, so he may
No
take
problem.
a little
Let
time.
him come in.
Second, my lords, I must take the opportunity to introduce Mr. Chandyok, my lords, from the Delhi bar.
Yes.
My lords, when people from South India landed up in Delhi, we took the blessings of his father, Mr. A.S. Chandyok, who was the leader of the bar.
Yes.
Therefore, my lords, he's welcome in our court, my lords, and therefore I want
My lords, before entering this, we take his blessings. Thank you so much.
Yes. So you're appearing in which matter, sir?
My lords, 1.40, my lords, I present Samsung Electronics.
Samsung Electronics. Yes, sir.
Lords, with the permission of this court, my lords. For 1.7, my lords, submissions have been extensively covered, my lords. I'll just adopt those submissions.
1.7.
7.
Once. I'll just make it 1 minute.
My lords,
Lomesh.
my apologies.
No problem.
1.7, which covered in by whom?
Covered by Mr. Raghavan as well as Mr. Poya, my lords. It's on the same
So you're adopting those
We are
submissions?
adopting those submissions.
Yes.
My lords, with your permission.
Yes, sir.
My lords, I appear for Samsung Electronics. To the extent that Mr. Povaya and Mr. Raghavan has already covered, I will not I will attempt at least not to overlap those submissions. But my lords, let me first start why we are here, my lords. My lords, we are here challenging an order by the CCI of 28th of August 2024, which makes us a party to these present proceedings. There is a DG report, my lord, which also includes us as a party to this investigation, to this inquiry. And third, my lord, is the question with regards to that when another respondent, which was Apario Retail, was searched. My lords, at that time, my employees were present. They were visiting those premises. And at that time, certain procedural lapses took place, my lords. And that will be the third part of my submission. But I will concentrate.
If you can use the...
My lords.
Yes.
As far as prayers 1 and 2 are concerned, my lords, I think it's important for us to start at the very beginning with the order initiating the investigation.
Yes, sir.
My lords, you'll find that at page 66 of my paper book.
Yes.
At annexure P2.
Yes. Sixty-six.
66 one.
Yes.
My lords, will first note from the cause title.
Yes.
In the, as far as opposite parties 1 and 2 is concerned, it is Flipkart Internet Private Limited and its affiliated entities.
Yes.
And similarly for Amazon, my lord. My lords, affiliated entities, my lords, whether it is the law lexicon by Mr. Iyer, whether it is Blacks, always say that affiliated entities means entities under common control or ownership. As far as I am concerned, my lords, there is no common control or ownership as far as I or Amazon or Flipkart are concerned. My lords, may please see the first paragraph. The present information has been filed by so-and-so society registered under the Society Registration Act and under 19(1)(a) of the Competition Act, here and after the Act, alleging contravention of the relevant provisions of section 3(4) read with 3(1) and 4(2) and with 4(1) of the Act by Flipkart Internet Services Private Limited and Amazon Seller Services Private Limited, here and after collectively referred to as opposite parties. My lords, further down in that, my lords, in 7.3, my lords, apologies, we'll come to 22 directly.
Yes.
My lords, here the commission notices, as far as Samsung is concerned, the commission has also noted several reports in the media as well as advertisements by e-commerce portals regarding exclusive launches. Mobile manufacturing companies, OnePlus, Oppo, Samsung have exclusively launched several of their models exclusively on Amazon. Similarly, so-and-so have exclusively launched several of their models on Flipkart. In 2018, Flipkart launched 67 mobile phones and Amazon launched 45 mobile phones exclusively on its platform. Thus, it appears that these mobile manufacturers partner with e-commerce platforms and their brands are sold by platforms exclusive sellers. So they note this, my lord, but please see, come, my lords, down to 27, para 27.
Yes.
At 27, my lords, despite noting that observation as far as exclusive launches is concerned, the commission notes, in view of the foregoing, the commission is of the opinion that exists a prima facie case which requires an investigation by the Director General to determine whether the conduct of the OPs, again, my lords, Amazon and Flipkart alone, have resulted in contravention provisions of section 3(1) of the Act, read with section 3(4) thereof as detailed in this order.
Yes.
My lords, then the investigation starts, my lords, and that is it's sent to the DG. The DG starts its investigations. My lords, may have please annexure P4, which is the first notice that the DG sends to me at page 81 of the paper book.
Yes.
My lords will read the first, may please read the first paragraph. Whereas the Competition Commission of India, wide order dated so-and-so, passed under 26(1) of the Competition Act, have directed the office to conduct an investigation. The order of the CCI can be accessed at this web or the website. For the purposes of the investigation, certain information is required from your side. Now, my lords, I am put to notice. In the notice, it is clear that their investigation is only against Amazon and Flipkart. I am not a party to these proceedings. And therefore, there is no question here that I am being made or being arrayed as a party here. Second, my lord, comes the second notice at 132 P5.
One second. Yeah, page 132.
132, my lords, annexure P5.
Yes.
Again, my lords, the DG repeats, and whereas an information was filed under 19(1)(a) of the Competition Act 2002 by Delhi Vyapar Mahasangh, alleging anti-competitive practices in violation of section 3 and 4 of the Act in the business model adopted by opposite parties and its affiliated entities in collusion with preferred sellers. My lords, this is important here because I am not a seller. There are three categories of parties which have now been arrayed as parties. Number one is Amazon and Flipkart and their respective affiliates. Number two are preferred sellers or sellers on the Amazon Flipkart platform. And third, my lord, are OEMs. I am the third category. So even in the second notice, he only talks about, the DG only talks about Amazon, Flipkart, affiliates and preferred sellers, does not go into OEMs. Similarly, my lord, may see the third DG notice, just to mark, my lords, I've already made that point here.
Yes.
Again, it only speaks of preferred sellers, does not, this is annexure 140, sorry, at P6 at 148.
Yes.
Again, my lords, will see at the very end of the first paragraph, it says, and preferred sellers.
Yes.
My lords, then the DG begins to write his report, and that report, my lords,
Page.
my lords, will start at page 163, P7.
Yes.
My lords, in its report, again, the Director General only states two opposite parties, opposite party 1 and opposite party 2. Further down, my lord, we'll see page 216, where the introduction of the parties is mentioned.
Yes.
Again, at the end of para 1.1, again, the two OPs that have been identified are Amazon and Flipkart alone.
Yes.
In the next one, paras 1.2 all the way to 1.4, my lords, in the same page, again, the only parties that have been referred to are the informant, which is the complainant here, and opposite party 1 and 2. There is no mention of any reseller. There is no mention of any of the OEMs.
Yes.
Here, my lords, then the report takes a curious turn. And this is where, my lords, you'll see at 8.26, page 321.
Yes.
My lords, this talks about the anti-competitive practices that have been found.
321.
321, my lords, para 8.26.
8.26.
8.26. My lords, at 8.26, the DG is concluding to say, thus, each of the anti-competitive practices alleged vis-a-vis existence of preferred sellers, vertical arrangements, exclusive launch, preferential listing, and deep discounting were investigated and found to be true and in contravention of 3.4, read with section 3.1 and or section 3.1 of the Competition Act.
Yes.
My lords, he then describes what the contravention is, and the next page, my lords, at 8.27 says, the above issues and their effect on competition vis-a-vis the law was explained in detail in the corresponding chapters in this report. The investigation thus comes to the conclusion that the enterprise arrayed, my lords, please may note that, arrayed in table 254 have deliberately, with full knowledge and intention, have indulged in the anti-competitive practices. My lords, the word array is important, my lords.
Yes.
Similarly, my lords, at 8.30, which is at page 323.
Where do I get this table 254?
My lords, it starts at 324, my lords.
Oh, this is the table.
Yes.
All right.
Where Samsung is also mentioned.
Yes. Yes.
My lords, Samsung is mentioned at 359 at serial number 3.
Yes.
My lords, here, may I just take you back, my lords, again to 323 at para 8.30.
Yes.
My lords, you will see the second sentence in the paragraph starts with further to be noted.
Yes.
Further to be noted that even though most of the OEMs are indulging in practices of exclusive launch, only 6 of them were arrayed. So, my lords, this is where the first discrimination or the arbitrariness by the DG takes place, my lords. He notices that this is a practice industry-wide. Let's assume on a demura that this exists, my lords.
But picks only 6.
Picks only 6. That's, my lords. And second, does the same, is that he arrays us as a party in the DG report. My lords, here it's important to know, my lords, that if I may just draw your attention to the distinction in the role of the DG in the MRTP regime, my lords, versus the competition regime. In the MRTP regime, my lord, we had DG INR investigation, my lords. DG INR had suo moto powers, versus as far as the Competition Act is concerned, the Competition Act is very clear. The DG's role is only to assist the Competition Commission. It is confined by the order passed under section 26(1), which is a prima facie order saying that there has to be an investigation into these alleged anti-competitive practices. My lords, here the Raghavan committee, which was a committee which was set up prior to the enactment of the Competition Act is laws may just have the case compilation. I may just show through the case compilation. Whereas the Raghavan committee starts at 194.
Yes.
My laws may have 6.18 at page number 198. Investigation and prosecution.
Yes.
The investigation prosecutorial wing should be separated from the investigation wing. At the apex level of the investigator and prosecutorial wings, there may be only one official who may be designated as Director General, Investigation and Prosecution. The Director General will not have suo motu powers of investigation. He will only look into the complaints received from the Competition Commission of India and submit his findings to the Competition Commission of India.
That's a shift from the earlier regime.
That is the distinction from the earlier regime, my lords. So therefore, where the DG arrays parties, he falls into error and exceeds its remit because he has no jurisdiction at all to be able to array any person as a party. The only thing the DG could have done and did not do, my lord, this is an investigation which started in 2020, would have gone to the CCI, sought permission and done so. But in the 15 times during the course of the investigation, the DG goes to the CCI and seeks extension of the investigation period. At no point does the DG at any point say,
Takes permission to draw you as
you want permission to draw us as parties. So, my lord, that is the first error, my lords. Then the second error happens as far as the impugned order is concerned. My lords will find the impugned order at annexure P1, page 54 of the paper book.
51.
54, my lords.
Of which paper?
Of the writ paper book.
Yes.
My lords, the order starts at 56. The matter was taken up in ordinary meeting held today, wherein the commission considered the investigation report qua Amazon sellers dated 9/8/2024, submitted by the Director General in confidential, non-confidential.
54, right?
54 it starts, my lords. The order.
What are you reading now?
My lords, 56. Sorry, my apology. The order starts at 56.
Yes.
This is para 1 of the order.
Yes. Yes.
My lord, so in para 1, the CCI considers the DG report. It says that the matter was taken up in ordinary meeting held today, wherein the commission considered the investigation report for Amazon seller services dated 9/8/2024, submitted by Director General in confidential and non-confidential version. My lords, the matter was split. One report was prepared qua Amazon and the other was prepared via qua Flipkart. And the matter was split, say identical orders that were passed in both. In para 2, my lords, the commission notes that in the investigation report for Amazon seller services, the DG has found following entities to be liable under 3(4) Redway section 3(1) of the Competition Act. And my lords, and then proceeds in para 5, which is on the next page. At this stage, the commission decided to forward an electronic copy of the non-confidential version of the investigation report for Amazon seller services to the informant and aforesaid 13 entities OPs in the present matter for filing their respective objection suggestions, if any, within 4 weeks of receipt of the order, and then it goes on. My lords, here, this is where the CCI does first, my lords. First, it makes me a party. And as far as Mr. Povaya had referred to the MRF decision as far as Madras High Court is concerned. The MRF decision, my lords, I'm not going to repeat it here. The MRF decision says that when there is a change in the nature of the party from category from a third party to an opposite party, notice must be given to that party. And without notice, the entire proceeding must fail. Second, my lords, is that the CCI in its reply says that this, as far as the OP, as far as I am the petitioner is concerned, is my new prima facie order as under section 26(1) of the Competition Act. If that were to be so, my lords, the law requires the CCI to pass a speaking order. It requires them to show why that prima facie determination has taken place. And my lords, in that respect, my lords, may I just draw your attention to a Bombay High Court judgment in Star Cement, if I may just pass that across.
It's not here in this compilation.
It's not there, my lord. Apologies.
Yes.
The para number. My lords, may I have para 83,
This
please?
is for what preposition?
That the standard of the prima facie order the CCI must adhere to while coming to a decision whether or not a prima facie contravention of the Competition Act has taken place. What is that test under section 3.4? My lords, the charging section is section 3.4. What test that has to be taken place at that time? My lords, may I please have 83?
Yes. In the impugned order.
Yes, in the impugned order, in order to hold a prima facie contravention of section 3.4, the CCI ought to have formed a prima facie view that there exists an agreement either between Star Sony and NSTPL, which provides for a refusal to produce, supply, distribute, store, or trade in goods or provisional services with to NSTPL, and that such agreement causes AEC. AEC, my lords, is appreciable adverse effect on competition. However, there is no finding that the petitioners have refused to produce, supply, distribute, store, or trade in goods or services with to NSTPL. CCI was under an obligation to arrive at a prima facie finding that the conduct of the petitioners causes AEC. Since there is no prima facie finding by CCI on AEC, according to us, the mandatory jurisdictional prerequisites of a prima facie view of contravention of section 3.4 is absent. Therefore, once again, we are unable to find any reasonable justification justifying CCI's failure to apply the aforesaid analysis whilst passing the impugned order. That being so, the impugned order cannot stand the test laid down under the Act. My lords, as far as all the CCI has done is simply noted that the DG has found these parties to be in contravention and nothing beyond that. So there is no application of mind either in law or in ink, my lords. Second, my lords, is the question of, my lords, what prejudice has been caused to us as a consequence of the fact that we are now under some new alien accelerated procedure under the Competition Act. The prejudice, my lord, is, for that, my lords, is important to notice first what is the powers of the DG. My lords, may I have the Competition Act, please?
Yes.
My lords, may I have 41, please? My lords, Director General to investigate contraventions. The Director General shall, when so directed by the Commission, assist the Commission in investigating into any contravention of the provisions of the Act or any rules, regulations made thereunder. My lords, so as far as my investigation is concerned, if this order, which the impugned order is the order by which the 26(1) process has kick-started, therefore the investigation cannot proceed as far as I am concerned. My lord, second is the Director General, subsection 2, the Director General shall have all the powers as are conferred upon the Commission under subsection 2 of section 30. If please have section 36. 2.
Yes.
My lords, the Commission shall have, for the purpose of discharging its functions under this Act, the same powers as are vested in a civil court under the Code of Civil Procedure 1908, 1908, while trying a suit in respect of the following matters, namely summoning and enforcing the attendance of any person and examining him on oath, requiring the discovery and production of documents, receiving evidence on oath, issuing commissions for the examination of witnesses or documents, requisitioning subject to provision of section 123 and 124 in the Evidence Act, any public record document copy. So, my lords, as far as the civil court is concerned, the DG has the same powers as the Commission, and therefore, my lords, in our submission, the trial commences. My lords, there's a division bench judgment in Google of the Delhi High Court, my lords, which brings home this point. My lords, may I please have where does Google start? My lord, Google starts at 47 of the case compilation.
Yes.
My lords, may I please have 18.
1.
At page 3. That's page 65, my lords.
Yes.
My lords, 18 starts with My lords, in this case, the division bench of the Delhi High Court, my lords, had an occasion to review the powers of the DG and the CCI, especially with regards to inherent powers of the CCI to review, recall its orders. In that context, my lord, the Delhi High Court concludes, we, for the following reasons.
Yes. Conclusions begin at 60.
60, sorry.
Page 60, yes.
We, for the following reasons.
Yes.
Conclude that order of the CCI direction to the DG CCI in exercise of powers under section 26(1) of to cause investigation is capable of recall. My lords, may please come down to para capital C, which is the next page.
Yes.
61.
Yes.
The DG, during the course of such investigation, by virtue of section 41(2) read with section 36(2) of the Act, has the same powers as are vested of a civil court in a civil court under the Code of Civil Procedure 1908. While trying a suit in respect of, my lords, I've already read these provisions. My lords, further, the DG is further empowered by section 41(3) read with section 240 and 240 of the Companies Act 1956 to keep in its custody any books, papers of the person enterprise investigated against for a period of 6 months, and to examine any person on oath relating to affairs of the person enterprise being investigated into and all officers, employees, agents of such person enterprise are also obliged to preserve all books and papers which are in their custody and power. D. Failure to comply without reasonable cause with any direction of the DG under section 43 of the Act has been made punishable with a fine extendable to rupees 1 lakh for each day of failure, subject to a maximum of rupees 1 crore. My lords, now this amount actually by amendment stands increased. It would thus be seen that the powers of the DG during investigations are far more sweeping and wider than the power of investigation conferred on the police under the Code of Criminal Procedure. While the police has no power to record evidence on oath, DG has been vested with such a power. Our experience of dealing with matters under Competition Act has shown that not only statement on oath of witnesses summoned during course of investigation is recorded, but said witnesses are also being permitted to be cross-examined, including by the informant claimant, and which evidence as part of the report the DG forms the basis of further proceedings before the CCI. Thus, while investigation by police under the CRPC, the rule of audi alteram partem does not apply, there is no such embargo on the DG CCI. Thus, the investigation by DG CCI tantamount to commencement or trial inquiry on the basis of an ex parte prima facie opinion.
Yes.
So, my lords, the DG under the Competition Act is certainly of a much higher threshold. A trial begins, my lords. And now that as far as the DG report is concerned, that stage having been crossed, where I have not had a chance to either lead evidence or to cross-examine any party, my lord, I have lost valuable rights to participate in a trial in which I am named as a contravening party.
Yes, sir.
My lords, here it's important, my lords, to just also kindly please note the regulations, the general regulations.
No, the paragraph you want to read?
Not of Google, my lords.
That's all.
Yes.
The division bench holds alphabet R.
My lords, alphabet is now the renamed of Google.
No, that's all right.
Alphabet R.
Not that.
My apologies.
At page 66, can direct only if prima facie violations of the Act are found.
Yes, my lord.
That is one thing. And the para 1920. Yes.
Oh. My lords, in 1920, my lords, they look at the powers of the CCI, that whether or not a hearing is required. But that is at the stage, my lords, when the information has been filed.
Why I told you that stage is crossed and you have lost that opportunity.
We have completely lost
that is why
indeed, my lords, we have completely lost that opportunity, my lords. And my lords, as far as cross-examination is concerned, Mr. Povaiya had referred to the Supreme Court decision in short class.
Yes.
My lords, may I just for a minute just read from short class?
Yes. Where do I get that?
My lords, it starts at page 13, and my lords, at page 14.
It's here, page 13. Yes, yes, yes. Paragraph?
1, my lords, starting with.
Yes.
So, My lord, the sentence starts with equips the Competition Commission with wide-ranging powers of inquiry and remedy, yet it permits intervention only where hard evidence shows that the impugned conduct has caused or is likely to cause a demand rigorous fact-finding, adversarial testing of testimony, and above all, an effects-based appraisal that balances commercial justification against proven harm. My lords, the Supreme Court also drafted made an issue, my lords. It is issue number 6, which has a page 40 of the compilation.
Yes.
My lords will see the issue whether the investigation, my lords may note the word investigation, and the commission's order are vitiated by denial of cross-examination and light breaches of natural justice.
I think this Poe has said is right.
My lords may just note that. My lords, as far as the trial is concerned, my lords, whether there is any admission denial, whether there has been any evidence that is led, whether that has been by way of affidavit or by way of oral testimony, my lords, that entire stage having been crossed, whether or not, my lords, had also Mr. Povaiya had also referred to the case of Gurushi High Tech and Sivagami, my lords. In those cases also, the proposition, my lords, that because I have suffered at one stage, it cannot be cured at the next stage, my lords. That follows from Leary, from that old 1970s judgment of Leary, my lords. And second, my lords, whether or not a statute provides or does not provide cross-examination is key as far as adversarial testing or testimony is concerned.
Violation of natural justice at the original level cannot be cured by the
cannot be cured at the next level. I'm grateful, my lords. My lords, the other question, so as far as MRF is concerned, my lords, I did not get an opportunity, the notice, I did not get that opportunity. As far as the Star Cement is concerned, the CCI did not cross the threshold of a prima facie order. As far as the trial is concerned, the judgments of Google, as well as the section 36(2), that entire stage having crossed, and as my lords have noted, as far as Leary and Guruswamy is concerned. My lords, the next prejudice was again pointed out earlier, my lords, was the fact that I am not in a position today to file a commitment under section 48B of the Competition Act. My lords, that point has already been made, my lords. And last, my lords, is what the CCI has done by splitting these proceedings is the fact that, my lords, the competition law, my lords, looks at conduct and looks at conduct in a general sense. These are proceedings, of course, in rem. When it's looking at, my lords, it's not looking at individual contracts or individual agreements between parties. It's looking at, let me illustrate this. My lords, suppose there is an entity which has exclusive contracts to sell pens, and that is with 10,000 different retailers, and that exclusive contract does not allow that retailer to carry the pens of any other manufacturer. That exclusive agreement may cause an anti-competitive effect, and if so, the CCI, so the DG has to weigh the anti-competitive effects with the pro-competitive effects of such conduct, and then arrive at a finding whether an appreciable adverse effect on competition has been. That, my lord, is the rule of reason test under section 3(4) of the Competition Act. Because I did not participate, I could not have even led evidence whether or not there were any pro-competitive outcomes from my arrangement. Second, my lords, is as far as the conduct is concerned, I can't be vexed twice by it. This is conduct. If this is conduct, let's again on a demo, this conduct exists. I cannot be fined both in the Amazon proceedings and in the Flipkart proceedings, because that would be vexing me twice for the same conduct. Because that conduct, my lords, that splitting done for the CCI for administrative purposes, the CCI cannot launch 2 attacks on me and then ask me for my financial statements in both matters and decide to proceed against me under section 27 if that occasion arises. Last, my lord, is the question of the CCI's own proceeding. My lord, the Competition Act came into force in 2009, my lords. We are in 2025 today. Despite this, we are still discussing these, and these are matters still which require determination as to what is the role of the CCI, what is the role of the DG, my lords. But interestingly, my lords, I have noticed that how that entire stage has been skipped. The CCI, my lords, is part of an international grouping. This, my lords, I'm arguing soft law here, is part of a grouping called the International Competition Network. It is a network of all competition enforcers, regulators across the world. My lords, they come out with best practices. They come out with trainings, best practices, and soft law, which inform the functioning of each of the authorities which are party to it. My lords, the CCI is also a party to this, and importantly, party to something called, my lords, the ICN framework on competition agency procedures. My lords, this is at page 200 of the compilation, of the case compilation. My lords may have 200 at page 205, H, small h, my lords. Notice an opportunity to defend. Each participant, the participant here, my lords, means the National Competition Agency, as they are called, the NGA, NCAs, National Competition Agencies. Each participant will provide persons subject to an enforcement proceeding timely notice of the alleged violations or claimed against them, if not otherwise notified by another governmental entity. To allow for the preparation of an adequate defense, parties should be informed of facts and relevant legal and economic reasoning relied upon by the participant to support such allegations or claims. Now, Roman 2, my lords.
Do you need a report for this? Too rudimentary.
My lords.
You don't need a report or other things for all this.
No,
it is
my lords,
it is too rudimentary.
It is too rudimentary, my lords.
Rudimentary for the reason that, yes, one should not be condemned unheard.
Indeed, my lords.
Is all the principle.
Indeed, my lords. Yes. And my lords, these principles have been in the agency procedures in which the CCI participated. It is it's a joint work product of the CCI itself.
So it's there from Adam and Eve.
Yes, indeed, my lords. My lords, my last contention is with regards to the search operations that were conducted against Apario Retail, my lords, which was also petitioned here. My lords, on 29th April 2022, search operations were conducted at the premises of Apario Retail. My lords, 3 of my employees.
One clarification.
My lord.
When search was conducted, were you issued notices?
None. My lords, I'm grateful, my lords, you have taken the words. I was issued no notice. My employees were present. Their mobile phones and laptops taken and cloned at that stage. No panchnama given. Nothing at that stage. No procedure which is enshrined under the erstwhile CRPC, my lords, has been followed. My lords, that is my limited contention. I'm very grateful, my lords.
So that finishes.
That finishes me. I wanted to keep it short and sweet.
That's precisely why I asked that. If there is nothing given to you and so many things happen, prima facie, unless they convince it's contrary to law. Yes.
Of course, in their reply, they have not mentioned it. They have just simply adopted a common reply.
Oh, that's nice.
Grateful, man.
Yes. Yes, next in line.
My lords, if I may please.
Serial number?
My lords, I am 1.22 and 1.23.
1.22 and 23. Just a moment, madam.
My lords, it's Realme and OnePlus.
One moment, madam. Realme OnePlus.
That's right.
Yes, ma'am.
My lords, I will try and not repeat the arguments that have already been presented before me. I have prepared a short note, my lords.
That's good, madam. Thank you, madam. Yes.
No. My lords, my petitions are a little different from the others to the extent that I'm not only challenging the impugned order of 28th August 2024, but also challenging the first order, which is received at the time of the first DG report, which is 1st May 2024. It is at page 85 of Realme's petition. I'm just giving a broad overview right now, my lords.
Yes, that's better. Before we go to the pages.
Yes, my lords. One is page 85, which is the 1st May 2024 order of the Competition Commission of India,
Yes.
The second is the order that has been much discussed before, my lords, which is of 28th August 2024.
Correct.
And I will refer to it as the August 2024 impugned orders. There are two orders because as Realme, I have been impleaded in the two split up cases, both pertaining to Flipkart as well as Amazon. And it's curious because the allegation seems to be of exclusivity, but I'm both in Flipkart and in Amazon.
Inclusivity is coming. Yes.
My lords, the third order is that of November 2024, which is 6th November 2024.
Correct.
And there are two orders again of that. And the reason why I've impugned that order is I had written in October of 2024 to the CCI asking them if they can serve or provide me with a copy of the order with which they impleaded me as a party. And they returned the finding back in the November 2024 order saying that they had impleaded me in the August 2024 order. And my lords, when I go through the arguments, I'll explain why the August 2024 order does not really implead at all. There is no adjudication at all in that order to implead me. Now, my lords, having said this, there are a couple of things that I would also like to present as background. I'm a brand, I'm not a reseller, and I'm not an affiliate of either Amazon or Flipkart.
That's a unique name, Realme.
Yes, my lords. The third is that I'm a brand owner and the fact that I was not raided. So those are the broad things.
Distinctive features.
Distinctive features. My lord, there are also some other distinctive features that apply to me as a party because I use the SBRT, which is the single brand retail trading notification of the government of India that was introduced in 2018 as another form of liberalization that helped me bring the companies, both Realme as well as OnePlus. They got incorporated after 2018. I'll come to the relevant dates. And therefore, the three issues that are relevant in the background to understand the petitioner's case is one, whether the petitioners existed in the market in India at the time of, on the date of the information and the date of the 26-1 initiation order itself.
All right.
The second issue is the larger economic policy of India and whether the importance of competition, basically the competition law concerns and the economic policy, which have been resounded and reaffirmed in looking at the preamble of the Competition Act in the short class judgment, which I had the privilege of representing short class in that matter. My lords, the third issue is the regulatory and the statutory compliances that are mandated on brand owners. With that, I'll start with the SBRT notification to begin with. My lords, it's somewhere in para 2 there of the note itself.
Yes.
My lords, the government of India issued the press note 2018 on 26th March 2018. I'm just relaying the dates because they will be important, which allowed 100% foreign direct investment in the single brand retail trading. In light of this foreign liberalized policy, Realme launched its phones under its brand in India and commenced selling the mobile phones in India. My lords, the incorporation date of Realme is 25th September 2018. The information is filed about 11 months later on 25th October 2019. The curious case is that OnePlus, which is the other item, was only incorporated on 8th October 2020, which is after the prima facie order was even passed. So it was not even in existence. It was not incorporated. It was not in the market in India. Yet by some degree of imagination, I have come to be made part of this DG report, which has been served on us. My lords, I would also like to mention that the fact that the phones that are made, under the brand name of Realme and OnePlus are sold also on my own website and were sold even on my own website, apart from being sold in on Amazon and Flipkart. So they were not exclusively sold both on Amazon and Flipkart. They were also being sold on the online medium of my own website. Apart from my own stores, because I came to India under single brand retail trading, I had to open my own stores. And there is the larger issue of COVID having hit us in 2020, just after I entered the market.
As you say, brick and mortar happened in 2022 December. Your own stores were established in 2022 December?
My lords, my stores were established sometime between 2020 to 2022.
All right, yes.
The brick and mortar stores, but I was selling on the website since the very beginning. So the date on which I made my first sales as Realme is April of 2019.
You did not sell it only through Flipkart or Amazon.
That's right.
You did it from your website.
That's right,
then established stores in the 2-year period.
Yes,
and began to sell through them.
Yes, my lords. My lords, it would be incorrect to state that the members of the Delhi Vyapar Mahasangh are my competitors, which is the informant, because there's a possibility, and I haven't really checked on that per se, but the retailers that I have may also be members of the informant.
Could be.
And therefore, they cannot be my competitors because I'm really a brand and they are resellers. My lords, at this stage, I'd like to first point out the preamble of the Competition Act for a minute, because then it will be useful to come to the short classes judgment and lay the parallel there.
Yes.
My lords, if I may, an act to provide, keeping in view of the economic development of the country. That's the primary action that is tasked to the CCI for establishment of a commission to prevent practices having adverse effect on competition, to promote and sustain competition in markets, to protect the interests of consumers, and to ensure freedom of trade carried on by other participants in markets in India and for matters connected therewith or incidental thereto. My lords, in view of the economic development of the country, the reason why this became important was that SBRT is the crux that led to another level of transformation or development or economic reforms in India, where 100% trading, single brand retail trading was permitted by a foreign-owned company, 100% foreign-owned company. And that's what led me to establish myself in 2019 and then in case of OnePlus in 2020.
So the drill goes like this. 26/3/2018, the SBRT comes into force. 2019. 2018. 18, the 100% investment.
Yes.
2019, Realme comes in.
Yes, my lord.
2020, OnePlus comes in.
Yes, my lord.
2022, Realme gets into OnePlus, and OnePlus is what is existing now.
No,
Is that the case?
No, my lord.
Or even
Realme and OnePlus are two separate brands.
Separately. Yes, and the prima facie information that comes about in October 2019.
That's right, my lord.
Was at the time when the OnePlus was not even in existence.
Yes, my lords. And Realme was only 11 months into existence.
Correct.
And therefore, that would mean that the crux or the threshold of 3-4, which was pointed out by Mr. Chandyok, of appreciable adverse effect on competition,
yes,
could not have been there by a company that is only 11 months old into the market of India.
No,
that already has players like Samsung, Apple,
you can always
etc.
come with a bang and create. Yes, that's all right in a lighter way. Yes. So according to you, 11 months is too nascent a period for any competition to generate. Yes.
Yes, my lords, to form an appreciable adverse effect
Correct.
on competition.
I was wondering whether
I didn't see you. Sorry.
being argument on the merits.
Oh, I didn't see your preference, yes.
I thought the entire matter being argued on the merits of what the commission will ultimately do. We are at an entirely different stage of investigation by the
No,
DG.
that's why I told, counsel said, she'll arguing on her own way, you can do it, yes.
Sir, I'm only giving the background, if I may be permitted. My lords, the background is important because I mentioned the regulatory paradigm and the preamble of the Competition Act requires the CCI to be mindful when it forms a prima facie view to think about all of this when it passes that 26(1) order. Now, my lords, I'm coming to para 1 of the short class judgment where the Honorable Supreme Court had taken note of that preamble and therefore starts on that point.
Yes.
My lords, I'm passing the compilation that has the case laws and some parts of the facts as well. My lords, short class is tab A, page 1, para 1.
Yes.
India's economic ascent rests on a delicate but decisive equilibrium. On the one hand, markets must remain contestable. No undertaking may extinguish rivalry by stratagems foreign to fair, merit-based competition. On the other hand, genuine achievement, whether expressed in scale, efficiency, or technological advance, must be rewarded and not punished. For it is the impetus for investment, innovation, and consumer welfare. The Competition Act 2002 is the charter that secures both pledges. It equips the Competition Commission of India with wide-ranging powers of inquiry and remedy, yet it permits intervention only where hard evidence shows that impugned conduct has caused or is likely to cause a demand rigorous fact-finding, adversarial testing of testimony, and above all, an effects-based appraisal. Therefore, the effects have to be shown. That balances commercial justification against proven harm. Preserving this symmetry between discipline and encouragement is essential if the statute is to nurture robust rivalry while sustaining the confidence of domestic and global investors who increasingly view India as a premier destination for enterprise and innovation. My lords may take note of para 78 and 79 as well.
You should have indicated paragraphs in the index. Page numbers are there. Paragraphs.
Yes, my lords.
Please indicate the paragraphs and give, so that it will be easier for me.
Yes, my lords. Paragraphs 78, 79, and 80 after 1.
I'll give this back. Just indicate the paragraphs afterwards.
I'll do that, my lords. Yes,
78.
My lord, 78, 79, and 80, apart from para 1.
All right.
Page 51 and page 52.
Yes.
My lords, in terms of shot glass, I'll just give a short background, which is that the product in question was glass vials for pharmaceutical purposes. And Kapoor, which was considered to be my competitor, had alleged that there was refusal to deal and the discount policy was anti-competitive by shot glass.
Yes.
My refusal was based on IP violation and espionage of Kapoor Glass, which is noted in the order.
Yes.
But the court takes note in para 78, if my lord has para 78.
I'm there.
Competition law is not designed to humble the successful or to clip the wings of enterprises that have, through industry and innovation, secured a commanding share of the market. The true purpose of antitrust laws is to preserve the process of competition. That is to ensure that rivals may challenge the incumbent on merits, that consumers enjoy the fruits of efficiency, and that technological progress is not stifled by artificial barriers. If mere size or success were treated as an offense, and every dominant enterprise exposed to sanction without tangible proof of competition harm, the law would defeat itself. It would freeze capital formation, penalize productivity, and ultimately impoverish the very public it is meant to protect. My lord, 79. In today's economic global climate, prudence is vital. As the United States and Europe retreat behind their newly minted trade walls of protectionist policies to shield their homegrown markets, India's bid to emerge as a global center for manufacturing life sciences and technology will succeed only if regulation rewards scale and intervenes solely when genuine competitive harm is shown. Heavy-handed enforcement divorced from market effects would discourage the long-term capital and expertise the economy urgently needs. An effects-based standard is therefore not a procedural nicety. It is both a constitutional bulwark against arbitrary restraint of lawful enterprise and a strategic necessity if India is to capture the opportunities that more protectionist economies are in danger of forsaking. My lords, finally in para 80, it was the Supreme Court had taken note that Kapoor Glass had litigated on a prolonged basis and therefore imposed a penalty, increased the penalty from 1 lakh rupees to 5 lakh rupees.
Yes.
The cost of 1 lakh rupees to 5 lakh rupees. My lords would also take note that this finding in para 1 and 78 and 79 came to be found because the preamble was pointed out and also because the court took notice that short class had entered India in 1998 after the liberalization policy in India of 1995. So it took note of that, and that's why I gave these.
Yes.
Noted these points.
Yes.
My lords, it's also important to note that CCI's decisional practice has not really gone against the idea of each enterprise themselves deciding their business practices and who to appoint as dealers, distributors, etc. So there are a few cases that are part of the compilation.
Yes.
One is Hive Loop.
4 cases.
Yes, my lords. It's tab B, my lords. Hive Loop, para 51.
B to E.
B to D, my lords.
B to D. E is the judgment.
Yes, my lords. B to D. Hive Loop is the first one. It is an order passed by the Commission itself in 2022, where it says nobody can seek an absolute right to deal, and even dominant enterprises have freedom to conclude contracts based on objective justifications. Basically, not force enterprises to appoint everyone and to deal with everyone if their business case is not made. And therefore, I'm connecting it back to the time when I just came into India. I could not have set up so many brick and mortar stores. It would take me time to scale up, and therefore to say and hold that against me at that point in time when the law and the regulatory regime did not require me to do so would be entirely unfair and unjustified and arbitrary on the part of the CCI and the DG both. My lords, similar is the case of C and D, as my lords has already noted.
Yes.
That and paras 52 in C for tab C. I'll try and go faster.
No problem. Yes.
My lords, it's page 110 of tab C. It's Hexa Communication Private Limited versus Atos India Private Limited. It's again a judgment of June 2022. And the CCI itself notes, in relation to the allegation of the informant that the opposite party does not warrant any service and support in respect of its products in India as provided by the informant, the Commission is of the view that a manufacturer has no legal obligation to warrant genuineness of products, spares, services offered outside its distribution channel, and any insistence that the same be bought from its authorized distribution partners in itself cannot prima facie be considered abusive or exclusionary. The Competition Commission notes the rights available to a manufacturer to protect the sanctity of its distribution channel and its goodwill in relation to the goods or services offered under its brand names. My lords, the same is the case, and it starts since 2014. The reason why I've not given all cases but given a spectrum, the Competition Act it came into force in 2009. So as long as from 2014 till about 2022, CCI has held this decisional practice that we are permitted as manufacturers to have a say into deciding who we want to appoint as distributors. And today the Supreme Court has made it clear that unless the effects have been proven to be harmful, And there is nothing in the prima facie order that also says so per se, that they have found an effect. Even to make a prima facie finding on that, there isn't any. They say we will have to investigate to find out if there is appreciable adverse effect. And I'll go into that also, my lords. My lords, my competitor are all mobile phone companies and mobile phone brands. Why will a company or a brand that is entering India not want to make more sales? It doesn't make a business case. If I don't want to sell more mobile phones, I would want to sell it, but not at the cost of both commercial sense, objective justifications that my business requires in terms of scale, and the overall intellectual property rights that I am required to protect because I am working under licenses. There's also a larger issue, my lords, with respect to the regulatory regime, which is that mobile brands have to adhere to something called an IMEI code.
Correct.
All mobile companies have to have that. And
Yes.
therefore, every trader and every small shop cannot be granted the phones because there is the large gray market that is known to exist with respect to mobile phones, and a huge security concern ever since 2020 has been found by the government of India, which they keep sensitizing all mobile brands on, that these IMEI codes, and we are supposed to report to the government agencies in terms of each of the IMEI codes also. So there's that regulatory aspect.
When asked.
When asked, we have to keep a list, maintain that list, and whenever asked, we have to supply those.
Now next is Snapdeal SanDisk.
Yes, my lords.
As it does not spring from an authorized dealer. Snapdeal was selling SanDisk.
Yes, my lords. My lords, para 21 and 24. This is at page 120. As far as Snapdeal,
I've read it. Yes.
my lords has taken note of para 21 and
21 to
24.
25.
Yes, my lords.
Yes.
My lords, now I'd like to come back to the first impugned order, having given this background of the regulatory framework, the fact that IP is also an important factor, and I have to work within these confines. The first is the order
1st May 2024.
180 at page 85.
1/5/2024.
That's right, my lords.
Yes. Page
85, my lords.
Yes, 1/5/24.
Yes, my lords.
Annexure A.
I'm sorry, my lords. My lords, annexure A.
That's where the exclusion takes place.
That's where the
separation
split
of Amazon and
takes place.
Flipkart order.
Yes, my lords.
Yes.
My lords would take note at the top of the page
Yes.
is the case number,
Correct. 40 of 19.
40 of 2019. My lords would also take note actually of the prima facie order for a moment.
That's 28/8/24.
My lords, page
You
111.
You have bracket 1.
My lords, yes.
Yes.
That's at page, that's later. But prima facie order, which is dated 13th January 2020, page 111. My lords has it.
Yes.
My lords, on top it says case number 40 of 2019. Now, my lords, at page 85,
Yes.
it again says case number 40 of 2019.
Right.
Therefore, the prima facie order was passed under case number 40 of 2019. It has already been pointed out, and I'm not going back to it, that it only had Amazon and Flipkart as opposite
Page
parties.
111 shows only 2.
Yes, my lords. Now, my lords, at page 85,
Yes.
again, it shows only Flipkart and Amazon. as opposite party. It says opposite party 1 and opposite party 2. My lords would take note of para 2 there. It reads, the matter was taken up in the ordinary meeting. My lords, an ordinary meeting is a one where CCI is required to give notice and call people for hearing. That did not happen. Held today, wherein the commission observed that the Director General DG has submitted both confidential and non-confidential versions of the investigation report dated 11th December 2023. My lords, this DG report has never been served on me. Even on inspection, I did not see a copy of this investigation report. Therefore, I have no way of challenging it. I have no way of knowing whether CCI did in fact, because something existed there, said what it said. The fact remains that even by CCI's own admission, until this date of 1st May 2025 or 2024, the OPs as per the DG report were only Flipkart and Amazon. My lords would take note of para 3. It says the commission in exercise of powers vested under section 36(1).
Yes.
Of the Competition Act decided to send back the confidential and non-confidential version of the investigation report dated 11/12/2023 along with all the case records to the DG with the direction to prepare and submit and complete investigation reports for Flipkart Internet Private Limited and Amazon Seller Services Private Limited in confidential as well as non-confidential versions, if applicable. My lords, CCI claims to be using a power that is under section 36(1). My lords, I will come to section 36(1) in a minute. That is not the provision that can be used to split a case and to say that they could separate and really order or direct investigation reports per se.
So it deals with power to regulate its procedure. So this is the power that the commission is exercised
My lords,
to regulate
it is
the procedure.
subject to the provisions of the Act itself.
Correct, subject to the provisions.
Yes, my lords. Therefore, the commission could not have used 36 to undertake a process of splitting which was not envisaged or is not envisaged under the Act itself, because it was subject to the provisions of the Act.
Yes, that's there. 36(1) says so.
Yes, my lords. So it reads,
or any rules made thereunder.
yes, my lord. So it says, in the discharge of its functions, the commission shall be guided by principles of natural justice and subject to the other provisions of this Act and of any rules made by the central government, the commission shall have powers to regulate its own procedure. Now, CCI seems to be laying emphasis on having the power to regulate its own procedure, but there are judgments that says that that cannot happen, especially if that regulation is subject to the other provisions of the Act itself. And the Act itself does not provide the CCI the power to split the case itself. My lords, I'd already noted about the ordinary meeting and the fact that principles of natural justice would come into play because there was no notice that was being given to the parties that they envisaged to add by way of the new DG report. It's quite apart from the fact that on its own, the power that is given under section 26, because subject to the other provisions of the Act would mean 26. That's where the CCI, the procedure of the investigation after the prima facie order itself is mentioned. And CCI itself had only two options, in my humble submission, to do two things. One, under 26(3).
Yes.
3 and 3B.
Yes.
The DG shall, on receipt of a direction under subsection 1, submit a report on his findings within such period as may be specified, and then what follows is 3A and 3B. If after consideration of the report 3A of the DG referred to in subsection 3, the Commission is of the opinion that further investigation is required, it may direct the DG to investigate further into the matter. My lords, it's only an investigation. The DG and the CCI is supposed to work not together, but one is to undertake an investigation on its own and submit that report to the CCI. CCI cannot have an interference in that investigation or the investigation report. By way of the first May 2024 order, what the CCI is trying to do is interfere in the investigation report itself that exists and say you now split it into two parts. That power does not exist. And create two separate cases of 40 of 2019 1, which pertain to Flipkart, and 40 of 2019 2, which would pertain to Amazon. My lords would also note that there is no prima facie order with respect to 40 of 2019 1 and with respect to 40 of 2019 2.
No, your OP 11 and 12 in 40 in 2.
My lords, but that is without an investigation.
That is the foundation sub.
Yes, my lords.
But where you spring in is at page 93.
My lords, that is the impugned order.
Correct. That is
also
for the first
of
time.
August 2024.
First time you come in as OP 11 and 12 there.
Yes, my lords. My lords, the first time that I come in as OP in para that have been mentioned as OP
Correct. That
12.
Is 12, and you're drawn here in case number 40 to 2019.
Yes, my
the
lords.
Second one.
Yes, my lords.
Yes.
My lords, the reason why I'm emphasizing on May 2024 order is that CCI does not have the power.
Correct. I understood.
Under 36 that it is claiming to have, because regulate its own procedure.
To split the case, there's
yes,
no
my
power.
lords. Yes, my lords.
And in the split case, you come in at page 93, drawing as OP 11 and 12 for the first time.
Yes, my lords.
On the foundation of 1/5/2024.
Yes, my lords. Yes, my lords. So, my lords, what I'm trying to also mention is that section 36 is really a chapeau provision. It really gives the broad conspectors. You can't rely on a chapeau provision to now use that as a procedure to say that I have the power, whether or not the larger act provides for it or not. My lords would come to Commissioner of Income Tax versus A.K. Das. Tab E, page 128. This is for the proposition that regulate its own procedure cannot be dehorsed the statute itself. My lords, in the middle of the page, it says it is. If my lords has the page now.
Yes.
Page 128. It is now necessary to examine the arguments put forward on this point by Mr. Roy on behalf of the assessee contending that the tribunal has a right to allow cross objections and regulates its own procedure. His first reliance is on section 255 of the Income Tax Act, which reads as follows. Subject to the provisions of this act, my lords has taken note, regulate its own procedure. The appellate tribunal shall have the power to regulate its own procedure and procedure of benches thereof in all matters arising out of the exercise of its powers or of the discharge of its functions, including the places at which the benches shall hold their sittings. On the basis, my lords, para 18. My lords, in your compilation, it's the very next para, it's not numbered. On the basis of this provision, it is said that the appellate tribunal has the power to treat the reply of the assessee in this case as a kind of a cross objection, raising the second question under reference. Prima facie, there appears to be a good deal of force in such an argument. On closer scrutiny, it appears that the significant words of that subsection are subject to the provisions of this Act. Necessarily, therefore, it must be subject to section 256. My lords, that's how it becomes subject to 26. 36 cannot be used on its own. It will have to become subject to 26 of the Act. Equally necessarily, therefore, the power to regulate the procedure cannot override the express provision regarding the requirement of an application in the prescribed form and such application to be within the period of time mentioned there. Thirdly, the appellate tribunal cannot be said to have power in the name of regulating its own procedure to follow a procedure which is directly against section 256 and the limitations imposed therein.
Yes.
Almost by the application of the doctrine of expressio unius, it will appear that the appellate tribunal, in making the reference to the High Court, has no power at all to evolve a procedure for cross objection as under the Civil Procedure Code. The tribunal is a statutory institution and has to find its powers within the four corners of the statute and its relevant sections. Section 253(4) in dealing with the appeals of the appellate tribunal expressly provides for the case of filing of memorandum of cross objections. It expressly gives the party other than the appellant before it the right to file a memorandum of cross objections verified in the prescribed manner against any part of the order of the appellate assistant commissioner, and it expressly provides such memorandum shall be disposed of by the appellate tribunal as if it were an appeal presented within the time specified under subsection 3. By sharp and deliberate contrast, this provision for cross objection has not been made in the case of reference to the High Court by the tribunal under section 256 of the Income Tax Act 1961.
Yes.
My lords, therefore, the submission that I'm trying to propound is that the May 2024 impugned order that has been
Contrary
passed
to section 36.
is contrary to section 26 because they ought not to have relied on section 36, and therefore section 36 will have to be read down, is one of my prayers in the petition. And the impugned order, as my lords has already pointed out, is the base or the foundation on which all future actions of CCI are predicated on. And therefore, if the order of 1st May 2024 is set aside, then all other orders by itself, the superstructure ought to fall.
Para 32 to 34 of Ananta Saha.
Deeply obliged, my lords.
It starts at 30, but 32 to 34. Coal India.
My lords is going much faster than I am. Deeply obliged for the patience, my lords.
Yes.
My lords, at the cost of being repetitive, 36(1) says CCI must be guided by principles of natural justice and subject to the other provisions of the Competition Act, CCI shall have powers to regulate its procedure, not in derogation thereof. They will have to find the powers within the confines of the Competition Act. They cannot go beyond it. My lords would also come to, although this was something that was referred by in the previous hearings, reference to the regulations, CCI general regulations 24 to 27. If my lords would come to that for a moment, regulation CCI general regulations, regulation 24, 2009, my lords.
Yes.
My lords, regulation 24 pertains to the power of the commission to join or substitute parties in the proceedings. Therefore, if a party had to be added, it had to be added either by availing the provision, the scheme that is provided under the Act. 24 is primarily the section or the regulation that can be relied on to add a party. And CCI has been granted the power to join multiple informations even after consolidation of two or more separate informations. And each such information shall continue to be identified by a separate docket number and case number.
Yes.
My lords, that is regulation 27, if my lords would take note. Therefore, even when they are combining informations, the case will have to be investigated and will have to continue under the original docket number, which is 40 of 2019. It could not have been split. This is a reaffirmation, regulation 27, that the split is not possible, because once a prima facie order is passed in a case or a docket number, it ought to continue in that lineage. And it cannot be that you pass a prima facie order in one case and then you split it in two, and then while there is no prima facie order in the split up cases and there is no investigation in the split up cases, you end up penalizing or passing a final order in those split up cases for which there was no prima facie order itself.
No, that's the prima facie against you is not found at all anywhere.
Yes, my lords.
Whether you are in one, whether you are in two, does not make any difference. The foundation is that there was nothing against, there is no prima facie order.
Yes, my lord.
So whether one or two will not cause any prejudice. The foundation is what is prejudicial.
My lords, the foundation is what causes prejudice. Also the fact that there are now although the claim or the allegation is that of exclusivity, I have now been made to defend myself under both 1 and 2.
No, one, you are not an opposite party at all.
My lords, I am an opposite party in one
also?
and in 2. Yes, my lords.
Where is it?
That's why I mentioned, my lords, that it's a curious case that the allegation is of exclusivity, but I am, my lords, page 87.
Where are you an opposite party in one?
My lords, opposite party 36. 88.
Oh, yes, I didn't see this. Yes, yes.
In both cases, my lords.
Both,
in one and
both
in
1
two.
and 2 you are there.
Yes, my lords.
1 plus is not there, only Realme is there.
Yes, my lords.
In 2, both 1 plus and Realme is there.
Yes, my lords.
Yes.
My lords, effectively,
I had not
there
seen
will be,
this, yes.
there is one prima facie order in 40 of 2019, not 1 and 2. 40 of 2019 is the prima facie order, but the final orders penalizing for me as Realme are contemplated under 2.
2, yes.
So the prejudice
Oh,
of me having to defend myself twice
You
over.
need not elaborate on that now. Yes. Because I had not seen this page 88,
Yes,
where
my
you
lords.
are 36 here. Yes. Now you are 1/5/2024 and all other things would make complete.
My lords,
Argument,
my
yes.
lords, yes. The reason why it becomes clearer that CCI has not impleaded me elsewhere is when CCI passed the November 2024 order saying that they impleaded me in August 2024. But when, my lords, I will go through it, I'll point out that there is no adjudication, there is no impleadment. CCI is only taking note of what the DG has said, not giving any adjudication, no reasons on their own. My lords, for a moment, I'm skipping a few and going to page para 102 of the note, my lords, if my lords would go to it. For a moment, my lords.
Yes.
This is a small tabulation that has been prepared to show the arbitrariness on the part of CCI and DG. Para 102.
Yes, I'm there.
Yes, my lords. My lords, the top is case number 14 of 40 of 2019, 40 of 2019 1 and 40 of 2019 2. My lords, this has been done with respect to Realme. This tabulation has been prepared in context of Realme. Therefore, it says that the information under section 19 was passed or existed in case number 40 of 2019. The prima facie order was passed in 40 of 2019. The DG's investigation under section 41 took place in 40 of 2019. The order of 1st May 2024, which
40
is
of 2019.
was also in 40 of 2019, not in 40 of 2019-1 and 40 of 2019. It's only when the second and the third DG report came to exist under the after the August 2024 order that for the first time that case number 40 of 2019-1 and 40 of 2019-2 came into existence. My Lords has taken note in terms of that case with respect to the expressio unius est exclusio ulterius, the fact that what is not mentioned in the legislation cannot be assumed to be added to the legislation, and therefore CCI cannot rely on 36 per se. My Lords, the next proposition that I would like to propound is that the formation of the prima facie order by itself under 26(1) is a sine qua non, is a jurisdictional threshold that CCI must pass, and it cannot delegate that upon to the DG, as it has already been pointed out that the DG does not have suo motu powers. It did have under the MRTP regime, but not under the current Competition Act at all. My Lords would take note of section 19 for a minute. The process, like I mentioned, the information or CCI itself acting under suo motu powers starts under section 19 of the Competition Act. So, my Lord, section 19 is interlinked to regulation 10, which gives the format and the contents of the information. I'll read 19(1) for a minute.
Yes.
The Commission may inquire into alleged contravention of the provisions contained in subsection 1 of section 3 of subsection 1 of section 4, either on its own motion or on receipt of an information in any manner and accompanied by such fee as may be determined by regulations from any person, consumer, or their association or trade association. My Lords, receipt of any information is to be taken note of. Now, my Lords, the contents of this information is what is given under Regulation 10. And the reason why it's important is it mentions very clearly the allegations have to be mentioned, and the allegations against respective opposite parties need to be mentioned. If the naming of the opposite party was not a requirement, and that the DG could on its own go ahead and keep adding parties without the approval or the permission of the CCI, then that requirement under Regulation 10 itself will also find itself to be superfluous. There will be no requirement to name parties per se in an information then, or to give allegations against them. My Lords, Regulation 10, the information or reference shall inter alia separately and categorically state the following seriatim: legal name of the person or the enterprise giving the information or the reference, complete postal address for delivery of summons or notice by the Commission, telephone number, fax number, mode of service of notice or documents preferred, legal name, E, legal name and addresses of the enterprises alleged to have contravened the provisions of the Act. This is what I was alluding to, my Lords, that one would have to mention the name of the enterprises alleged to have contravened the provisions. And I am certainly not part of one of the...
That's the record speaks for
Yes, my
itself.
Lords. My Lords would also take note of section 19(3).
19(3).
Yes, my Lords.
Yes.
At the time of passing a prima facie order, CCI is required. My Lords has 19(3).
Read, yes.
My Lords, at the time of passing a 26(1) or a prima facie order, CCI does not necessarily need to have a firm finding, but because it says prima facie opinion, it ought to have taken note of 19(3). Because only when there is 19.3, it could have made an order or it could have passed an order under 26.1. And it is
appreciable adverse effect.
Yes, my lords. And it gives the circumstances. It says, namely, it says creation of barriers to new entrants in the market. My lords, I am the newest most entrant into the market.
So you could not create any barrier.
Yes, my lords.
Yes.
Driving existing competitors out of the market. My lords, there is no allegation either in the information or the 26.1 order that there have been certain players or mobile brands that have left the market at all.
Today, in reality, many have.
No, my lords. There are many that have entered. They haven't really.
That's all right.
Yes, my lords.
Yes, yes.
Foreclosure of competition is another. Benefits or harm to consumers. My lords, there is certainly benefits to consumers because there is options that are available after the 2018 liberalization in the economy. And the new mobile companies that have come, and at different price points, now consumers have options and don't necessarily need to look at the two larger mobile companies that exist.
Apple and Samsung.
Yes, my lords. Improvement in production or distribution of goods or provision of services. Promotion of technical, scientific, and economic development by means of production or distribution of goods or provision of services. My lords, there has been promotion of technical, scientific, and economic development because, and there is improvement because there are newer companies that are coming and bringing in not only the new licensed products at a certain price point for the consumers, but also bringing in new technology with also parts of certain mobile parts being manufactured in India now. So there is nothing that could have been alleged against me per se under 19.3, and therefore I could not have passed, could not have affected or caused an appreciable adverse effect on competition per se. My lords would take note of section 8 for a moment, my lords. My lords, section 8 pertains to the composition of the commission, the competition commission itself. The reason why I'm pointing that out is, my lords, that in contrast to section 8 Competition Commission of India is a formation of a multidisciplinary personalities or professionals that are sitting, and there is a qualification that is mentioned under 8.2 there, which reads 15 years, not less than 15
composition
years.
of the commission was contrary to section 8 in this case?
No, my lords. What I'm trying to point out is that while there is reason why the addition of parties ought to be done by the CCI and not by the DG, because it's a multidisciplinary body having multiple people, not a single person. On the other hand, the DG is a single person and not proficient in terms of 8.2 requirements that are given for the CCI. And therefore, that function is only provided for to the Competition Commission of India. There's one more portion within the Act itself that points, my lords, towards the fact that it is the commission that is supposed to implead parties. If my lords would come to the newly added definition of the party itself, the definition of party at KA, 2KA, it says includes a consumer or enterprise or a person or my lords has 2KA, consumer association or trade association or the central government or any state government or any statutory authority as the case may be, and shall include an enterprise or a person against whom any inquiry or proceeding is instituted, and any enterprise or person impleaded by the commission to join the proceedings.
Yes.
My lords, it's clear. And any enterprise or person impleaded by the commission. That's what the definition of party itself says. Therefore, the Act is more than clear in several places that the impleadment ought to take place only by the commission. There are several judgments that also point towards that the power of the DG is not suo motu. If the DG finds material which predicates or pushes him or wants him to add parties, he ought to reach out to the CCI, take the permission, and then investigate them. He cannot use the existing investigation against other parties as material for the investigation for the newly added parties. My lords would come to tab H for a minute, please. My lords, page 201, para 37. It's a judgment of the Honorable Supreme Court of India, Competition Commission of India versus Steel Authority of India.
Sale, yes.
Yes, my lords. My lords, it says that formation of a 26(1) is a sine qua non and is a jurisdictional threshold for the CCI to meet. It must give reasons when it is impleading or when it is passing that 26(1) order.
Plastum B. Yes.
My lords, page 220, para 97, the last line says such view should be recorded with reference to the information furnished to the commission. It cannot go beyond the information
I've seen
to the
and marked.
commission. Yes, my lords.
Yes.
My lords, there is a point that I missed in terms of regulation 24. That is that regulation 24 says that a party is the one that an application needs to be filed by a party to implead other parties.
By an existing party.
Yes, my lords.
So Amazon and Flipkart had to file?
My lords, also the informant. The informant is also a
had to
party.
file.
Yes, my
So
lords.
it's filing an impleading application.
Yes, my lords, to implead other parties. And that is the reading of regulation 24 that I would like to render. That if the definition of party that is given under the regulations, the erstwhile regulations, that required even the DG as a party to file an application, is not to be accepted by my lords, then the three parties that are there is informant, Amazon and Flipkart. And if they preferred, it was up to the informant also to seek impleadment of additional parties. That by admission has not happened in this case also. My lords, regulation 24 is an application which will require adjudication and therefore a hearing. That entire process has been given. I'm not repeating it, my lords.
Given a go by here.
Yes, my lords. It has to be to the satisfaction of the commission.
Yes.
The impleadment again has to be done by the commission. It notes that.
Yes.
My lords, I'll not burden my lords with barium and the others where not. My lords, it's at tab T, page 540. I'll just mention the proposition for which I am relying on barium, which is that the requirement of a reasoned order to be passed based on relevant material showing application of mind to material that suggests the possibility of alleged contraventions is an important safeguard, the importance of which cannot be minimized.
Yes.
My lords, para 36 of barium is what I'm relying on.
Mm.
Page 540.
Yes.
My lords, the judgment of MRF by the Honorable Madras High Court has already been cited, but there's also another judgment in that same batch matters, which is of Hyundai Motors. It's a tab I.
That's division bench.
Yes, my lords.
Where 26(1) is explained.
Yes, my lords.
Yes.
My lords, I'm placing reliance on para 6 at page 232 of the compilation.
Yes.
The said complaint was taken on file by the Competition Commission after observing the formalities of section 26(1) of the Competition Act, and the Competition Commission had directed the DG of investigation to conduct an investigation into the matter to file a report within the stipulated time. After observing the procedures therein, the Additional Director General has filed a report dated 19/4/2011 stating that the investigation made by him revealed that similar practices as alleged in the complaint are adopted by other car manufacturers in India in areas of after-sales service and procurement of spare parts. And thus the additional DG, this has already been done, my lords, by the DG. So the DG is aware that as per their own previous practice, they would write to the CCI to add parties. Because what it notes here is, and thus the Additional Director General sought permission from the Competition Commission to expand the scope of the investigation to cover other car manufacturers not specifically mentioned in the complaint by Shamsher Kataria.
Yes.
It's only after that is done that in para 7 they note, based on the said report of the Additional Director General, the first respondent, Competition Commission of India, by an order of 26th April 2011, granted permission by approving the request of the DG. My lords, I'm coming straight to para 25 from there.
Yes, 25.
At page 237, my lords.
Correct.
The next limb of the argument is that the second respondent DG has no suo motu power. It is also noted there. No doubt it is true that the second respondent has no suo motu powers to investigate.
Yes.
That is clear within the act also. It's there under section 41 that the DG is to act only on the
yes.
The DG is to act only on the directions of the CCI and not on its own. My lords, my colleague in the morning, Mr. Chandyok, had already mentioned Google. That's at
Google MRF.
Yes, my lords.
Yes.
At it's at tab K, page 266. My lords, I'd like to only add that the matter has travelled to Supreme Court and there is no stay on this order. Therefore, this is good law even today and is being relied on by the division benches in different writ petitions before the Delhi High Court even today.
One is Ultratech.
Yes, my lords.
All right. Yes. Page 472.
Yes, my lords.
Yes. Next is what?
My
If a
lords,
statute prescribes
CCI
a mode to be done in a particular way,
my lords,
it
yes.
has to be done or not done at all.
Yes, my lords. Basically saying that CCI cannot subdelegate the power to the DG itself, and therefore, because that is not provided under the law, CCI could not have allowed the DG to do that.
Marathwada. Para 20 of Marathwada.
Yes, my lords. My lords, tab Q is Marathwada University.
Para 20 of that.
Yes, my lords, para 27 first.
No, first para 20, before they extract. 4 lines before they extract.
You have 20.
Where is Marathwada here?
My lords, tab Q, page 461 is para 27. I would assume it would be
461. Para 20. 4 lines before they extract. Subdelegation of powers.
It is settled. It is settled
Principle that when an act prescribes a particular body to exercise the power, it must be exercised by others unless its delegation is permissible. If delegation is not permissible, it's not permissible.
Yes, my lords.
Next proposition.
My lords, the reason why the impugned order, the August 2024 impugned order is relevant in my case is for twofold reasons. One, that the November 2024 order of CCI, which is at page 198. It starts at page 98, my lords. And my lords would take note of para 9, which is at 104.
Yes.
My lords, in the middle of para 9, My lords, it will be useful to note at page 99, second from bottom is Realme, which is OP36.
Yes.
Therefore, para 9, middle of the para, my lords has it, page 104.
The commission noted OP 36.
36 has been provided with a copy of the order dated 28/8, which was received by it on 13th September 24. Thus, OP6 has already been provided with a copy of the order in which it has been impleaded as a party to the matter.
Yes.
Now, my lords would take note of the impugned order, August 2024 impugned order for a moment.
Yes.
It starts at page 87.
Yes.
My lords has para 2 at page 89.
Yes.
My lords, I'll read from para 1 for a moment. The matter was taken up again in the ordinary meeting, but no hearing granted. Held today, no hearing granted to me because I am being added as a party, my lords. Therefore, there ought to have been notice to me. Held today, wherein commission considered the investigation report. Again, it is qua Flipkart
And Amazon.
Yes, my lords. But this one is with respect to Flipkart. So they are only referring to Flipkart. Investigation report qua Flipkart submitted by the DG in the confidential and non-confidential version. Para 2, the commission noted that in the investigation report qua Flipkart, the DG has found the following entities to be liable. It is the DG.
Yes.
So commission is only noting that the DG has found this and it's taking note of it.
Yes.
My lords, then we go to para 3, page 91.
Yes.
Again, the commission notes that the DG has found. So it's not commission's own finding. It's not commission doing any adjudication. Therefore, it's not commission impleading me also. Opposed to what commission's position is in the November 2024 order at page 102, that commission impleaded me in the August 2024 order. There is no impleadment. My lords, it becomes clearer in para 4. It says at this stage, the commission decided to forward an electronic copy.
Yes.
Of the non-confidential version to the informant and 40 aforesaid entities, OPs in the present matter.
Yes.
My lord, it traveled from commission noting in para 3 what the DG had found to suddenly forwarding the report to me without any adjudication and calling me an OP. It doesn't add me as a party. There is no adjudication, my lords, which is what I wanted to point out.
Yes.
Therefore, it is very clear that the November 2024 order, wherein CCI says that they have
There is no adjudication to draw you as an opposite
yes, my
party.
lords, has not been done. My lords, it's curious that as per the Competition Act, Section 48, CCI has the right to
Compound.
to go against individuals and penalize individuals who were responsible towards the company. The challenge to the Section 48 and its interpretation by CCI is already under challenge. Be that as it may, the reason why I'm pointing out 48 is that the DG report blacks out and says that the personnel of my companies that they have found to be in violation is also confidential. I have not sought that confidentiality. So I don't even know who are these persons and whether they continue to remain part of the company itself.
Where do you get that? Striking
My lords,
off?
it's not part of the DG. The DG report has not been made
Which
part.
page do I get that?
My lords, it's not here.
Not here.
It's not on record, but I can put it as part of.
Make it a part of the record.
Yes, my lords. I'll do
Have
that.
a copy and make it a part.
Yes,
of
my
the
lords. I'll do that. The reason why I point out this is that the arbitrariness and the non-transparent way in which CCI has decided to go ahead and allowed the DG to go ahead is to the extent that I'm not even supposed to know the personnel of my own company that they intend to go after. And they may be required to submit their financial statements, etc., of particular financial years. But they've put it as a black mark there. Therefore, that's also not.
Place that, yes.
Yes, my lords. My lords, I'd
So
like to
all your
rely
propositions are
on
over.
Excel.
All your propositions are over now.
No, my lords, just
G, arbitrariness.
My lords.
No, in your note, what you have said. H, I.
My lords, I had gone to the November order only to connect it to the August 2024, because otherwise it's not possible to show that there is no adjudication. And why I'm saying that, I was not really added as a party or impleaded as a party under the August order. My lords, under para M, tab M of the compilation is another case of the Supreme Court, which is Excel Crop Care versus CCI. My lords, in terms of the background, I had the privilege of representing Excel Crop in this matter, my lords. In terms of background, the matter pertains to Section 3 violation by 3 companies.
Yes.
The allegation was that of cartel, and the information was filed by a company, government company called Food Corporation of India, alleging cartelization for a product or in a product for tenders of aluminum phosphide tablets. In this case, there was no addition of party per se. And more often than not, we've seen in competition cases that CCI comes back and use paragraphs from Excel Crop to suggest that DG has powers to add people. But to clarify the matters, my lords would have page 395 for a moment. This case did not involve addition of parties. This case involved the Food Corporation of India informant writing another application to the DG saying that apart from one tender of 2009, there is an additional tender of 2011 that ought to be investigated. And Excel Crop Care had objected to that additional tender being investigated because it was not part of the information. And the CCI had permitted the DG to investigate 2011. The allegation was that, the objection was that the DG ought not to have investigated the 2011 tender. The Supreme Court finally held that during the course of investigation, if there is material pertaining to those same parties, additional material that is found, then the DG is within his rights to use that additional material as well, and therefore also pass orders with respect to 2011 orders, 2011 tender. My lords, has page 3, para 3 at page 395 for a moment in Excel Crop Care. An inquiry in this case was initiated by CCI on the basis of a letter complaint dated 4/2/2011 written by the chairman of Managing Director and Managing Director of FCI to CCI. It was alleged that the complaint that 4 manufacturers of APT, that is aluminum phosphide tablets, had formed a cartel by entering into an anti-competitive agreement amongst themselves, and on that basis they had been submitting their bids for last 8 years by quoting identical rates in the tenders invited by FCI for the purchase of APT. Yes. It was alleged that the requirement of APT was almost got doubled during 2007 to 9 and was likely to rise further in view of the requirement of large quantity of these tablets by FCI, Central Warehousing Corporation and other state agencies for preservation of food grains, which these agencies were storing in their godowns.
What's the proposition you want to canvass?
My lords would have para 44 for a moment, page 416. This is just to point out the facts that it pertained to same parties, not addition of party. CCI had entrusted the task to DG. My lords, has para 44.
Yes.
CCI had entrusted the task to DG after it received representation complaint from FCI via its communication dated 4/2/2011. The argument of the appellants is that since this communication did not mention about the 2011 tender of FCI, which was in fact even floated after the aforesaid communication, there could not be any investigation in respect of this tender. It is more so when there was no specific direction in the CCI's order dated, my lords, this is the objection.
Yes.
My lords, within the para 28 that is quoted under para 44, last 5-6 lines, there can be no dispute about the proposition that the DG on his own cannot act. And unlike the CCI, the DG has no suo motu power to investigate. It is clear from the language of section 41.
Yes.
My lords, therefore, even Excel from the Supreme Court points out and reinstates that section 41, DG does not have suo motu powers. My lords, para 29, because it is reproducing the part of the compat order that the Supreme Court had included within its order. So para 29 of the compat order, which is the next page, at page 417, we have absolutely no quarrel with the proposition that the DG must investigate according to the directions given by the CCI under section 26(1). There is also no quarrel with the proposition that the DG Director General shall record his findings on each of the allegations made in the information.
Even I have no quarrel. Yes.
My lords, with respect to adding of the party, there's also the judgment of Cadila Healthcare.
Affirmed the Supreme Court also.
My lords, where the Supreme Court has stayed the order of the DB, which did not agree with the adding of the party being done.
That's only stayed, is it?
Yes, my lords. So the Supreme Court has stayed that order of the DB. It says no coercive action, and in another case before the Delhi High Court, before the division bench of the Honorable Delhi High Court, that Supreme Court order has been relied on of no coercive action with respect to addition of parties in some other cases also. It seems CCI is in regular practice. My lords,
Zydus Healthcare.
My lords, first is N, which is the Supreme Court order, tab N, at page 445.
Next is 8/11/24 order.
446, yes, my lords.
No coercive steps.
Zydus Healthcare,
Yes.
which is Delhi High Courts.
And again, Sun Pharmaceuticals.
Which also relies on the Cadila Healthcare.
No coercive order.
Yes, my lords. My lord, this is only to point out because more often than not in a situation like this, CCI tends to come up and read the DB's order passed in Cadila Healthcare. It's to point out already that that order has been, that there's an order by the Supreme Court that stays or says no coercive action.
That's not a stay.
Yes, my lords, but it says no coercive action.
Not to take coercive steps, square the parties.
Yes, my lords, the additional parties.
Law that is declared still remains the law.
My lords, especially because now in the division bench of the Honorable Delhi High Court is repeatedly relying on that position.
No, that's like it's the preposition. Yes.
No, I was only trying to say the learned friend cannot know to read my mind at this point of time. What the competition?
My lords, with deepest respect, I am not trying to read mind because there was a previous round when the arguments were made by both sides, and I did have the occasion of being in the audience.
Yes. What remains? I think you've covered everything now.
My lords, there is one judgment of Capital Broadways Private Limited at page 466. It says non-application of mind. It's for the proposition of non-application of mind for para 14.
Minimum requirement.
Yes, my lords. My lords, Mohammed Shiab, which is tab U, page 594. Mohammed Shiab versus NIA.
My order.
Yes, my lords.
Others, if something cannot be done directly,
yes,
cannot,
my lords.
Yes,
yes, my lords.
What cannot be done directly cannot be done indirectly.
Yes, my lords.
That was, I think, with regard to police diary.
My lords, I'd like to conclude by saying that the May 2024 impugned order, if that goes, nothing survives beyond, and therefore my lords may not even need to go to examination of the
Correct, that's
August.
the foundation, rest is the superstructure.
Yes, my
If the
lords.
foundation grows,
Yes, my
superstructure
lords.
tumbles down.
Yes, my lords.
That's all.
Deeply
Yes.
obliged. My lords, I pointed out in the hearings before that there is no counter that has been filed to my petition, although the grounds are
No, I think
substantially.
I've adopted, is it?
My lords, the arguments or the
Yes.
propositions are different, but there's no separate counter that has
But I
been
find
filed.
a lot of statements have been made which probably goes beyond the pleading. I'll closely look into it. In need be, I'll put in a
No,
statement.
no. Please. Yes.
No, my lords. My lords, I may be granted an opportunity to rejoin in case there is a counter given orally to things that have not been said in writing.
No.
What I have
The
just
learned
stated, my
attorney
lords.
says things that have been argued are not in the pleadings.
My lords,
So
that's.
you can expect the same thing.
My lords, if not necessarily that, but if I can be allowed to rejoin and
Sorry,
say that that's not the case.
At the relevant time.
And justify.
Once let
Deeply
them-
obliged, my lords.
Yes, the attorney, sir.
I've been given a whole lot of wealth of material, judgments, propositions.
Yes, a detailed note is given. I think 3 of them have concluded today.
My lords, there is one more petition, my lords. We had mentioned on the last occasion, which is 1.32. My lords, that's a matter from the Delhi High Court that's been transferred, which doesn't pertain to the same interim order. It is a matter that was filed in Delhi in 2022.
It should be dealing, is it?
My lord, this should come, we'll argue it after this, these are completed, my lord, because these are impugned orders are completely different.
Why can't
I'm led by Mr.
everybody
Holla
come
in
to
that.
the argument so that I know what to
Now,
argue?
attorney, sir, would you reply to the submissions? Or you want all of them to complete?
I think all of them should complete so that we have, I don't want something which
A
is left
comprehensive
behind.
reply
That's-
later.
That's right.
My lords, in my matter, and I'm led by Mr. Holla who's coming.
It's
My
all right.
lords, that matter is itself filed in 2022, so it doesn't pertain to this impugned order.
We'll
And-
see about that. Let the
Please.
matter.
Please.
Now, anybody else? Nobody is there. For the petitioners,
I
I
find
think,
almost, the grounds which are almost
yeah,
common.
almost common.
Yes.
Because all of them are on the 3 impugned orders.
They don't want the commission to conduct an inquiry at all.
No, they, supervisor said, conduct an inquiry in accordance with law. Nobody is saying Competition Commission should not conduct an inquiry or it should not be done.
No, they
It
wouldn't
should
say
be done in
direct-
accordance with
they-
law by
they
giving them an
wouldn't say direct-
opportunity.
They wouldn't say directly.
No, in fact, the argument was that
They say,
we are
yes,
not running away from inquiry.
but let it be done the way we want it.
No, the way statute
Right by
wants
law.
it. That's the submission. Yes. So you'll reply, yes, Poe, sir. Now, there's nobody else left to submit on the petitioner's side. The learned attorney says he would submit a comprehensive reply after all the petitioners complete. So what do we do now?
Of course, my lord's convenience and at the learned attorney's convenience, whichever date suits.
No, tomorrow we're supposed to, I've listed this tomorrow. If nobody is there tomorrow, then we will.
My lords, in that case, the Delhi High Court matter that I just mentioned, my lords,
That would be, my lords, I just to clarify as a housekeeping. The Delhi High Court matter is not, my lords, on this issue of.
That's what he was telling. Yes.
That is on an issue of whether a magistrate's direction for search and seizure is correct, not correct. That possibly, my lords, could be heard separately.
Yes.
On the petitioner side, my lords, I doubt, I will check, my lords, with everybody.
I think
doubt there is anybody.
if everybody have completed, sir, then at the date of your convenience, you want to submit a comprehensive reply because nobody else remains. I think 8 or 10 of them have completed now.
That's right, that's right. So would it suit the court to have it on 28th?
Just 1 minute.
Adopt. Because most of them, legal submissions are common, except the factual. What the learned counsel, Anu, your name is Anu, right?
Yes, my lords.
Would it suit the court to have it on 28th November?
No problem.
Just to remind the learned attorney, it's a Friday, sir.
Supreme Court.
My my lords, if it can be a little later.
I
There's
thought
no problem at
continue
all.
on 29th also.
Now, I will now take it that the petitioner's side have completed their submissions.
Very well.
And for a reply by the learned attorney,
Very well.
we will fix a date. Which date?
My
You want
lords,
in
except for
December?
that 1.32, my lords.
And then separate. I'll
Yes,
take it separate.
Please, my lords.
We'll pass an order with it. No. Once the learned attorney would make his submissions on the submissions, sorry, make his submissions to counter. If there is any rejoinder, please.
Your Lordship, I appear for the informants. We are the informants before the CCI. After the attorney, Your Lordship, we would like to make some submissions.
You're appearing for whom?
The informant Delhi Vyapar Mahasangh. We were the
For the informant.
Informant.
There we have some
Yes.
objections. It's for the CCI.
We are a party to
Now,
a
the
lot of
informant
petitions.
wants to argue, my lords, in this matter, indicating that the CCI is correct. The learned attorney is here.
Correct, but informant also should have a.
My lords, there is case law on the point that informant in this case is, my lords, not the dominus. They have a truncated role. I'll place that. And then
No,
of
Your
course,
Lordship, that is
So
not
who's-
correct, and we are party to the petitions, Your Lordship.
28th, you Lordship will be here in person, my lord. Or minutes any other convenient day when you're not.
No, that would be only January. Because I'm sitting at Dharwad. I will come here whenever I will ask the permission Chief Justice and.
Sir, we can go to Dharwad.
28th is okay.
But maybe I will urge the learned attorney to come to Dharwad. Sir, the competition commission is willing to go to Dharwad, provided you
No, 28th, whichever
I would
date
love to
you,
go to Dharwad.
whichever date you suggest, sir.
27th and 28th, will it suit your lordships?
November 27, 28?
Yeah.
Yes. 28th will have, 28th is Friday?
28th is Friday, ma'am.
28th is Friday.
We'll keep it on 28th. For your reply, the whole day, sir.
Whole day. In case I may not able to conclude on that day, then it's probably then some other day. But 29th, I have some other engagement.
No, then 27, 28th.
27, 28th.
All right.
Right.
We'll keep it on 27th. No, your turn would come for rejoin the submission.
They can connect virtually, my lords.
Yes.
It's not an inconvenience.
No, that's then an attorney. Whichever date you tell, I will take the permission of Chief Justice.
27, 28th is.
No, the council is saying something.
Sir, if I can request either a little sooner. Be deeply obliged,
Very
sir.
difficult, very difficult.
Sir, a little later then, please. I'll not be able to hear
Here,
the arguments even
virtually?
my lords. I'll be
Virtual?
for other matters.
Maybe then.
You can reply on
If
some
it
other
suits the attorney on the 27th, I
You can
don't think.
reply
No, I
on
have
some
no-
other day.
Whatever date you indicate, I will.
She can reply on some other day.
No reply will be anyway later.
Reply is not on that day.
Yes,
We'll-
yes, yes.
We'll grant you time for a reply.
But he will take note on your behalf on that.
No, somebody, you don't have colleagues?
There are 4 of them, my lords, from Delhi.
Oh, yes, then what? Yes, so we'll keep it as 27th.
Very good. Very grateful, man.
Yes. We'll take it that adoption, somebody told me, which are serial numbers, sir? One minute. 1.162? 1.242, 1.29. So wherever Bhargav Bhatt appears, you are adopting the submissions of all the other matters of other senior councils. Tell me, madam.
And my lord, that 1.32 will be argued later, my lords.
1.32, sir. 1.32?
Please, madam.
We'll see. Yes. Jai Barkode. I heard the learned counsel, first, I forget heard the senior counsel?
No, not.
Heard the
senior.
counsel, current so-and-so, appearing for the petitioner in so and so, and the learned counsel Anu Monga, appearing for the petitioner in so and so. The learned counsel Bhargava D. Bhatt adopts the submissions made by the other senior counsels. The senior counsel, therefore, he has no separate submissions to make. The same is placed on the submission is placed on record. The learned attorney general seeks time to 27th and 28th of November. 27th, I'll just put it as 27th first. 27th of November to make his submissions countering the contentions advanced by the respective learned senior counsel for the petitioners. List the matter on 27th. 27th.
Yes, yes.
Yes, sir.
27th.
Lomesh, yes, that also. Seal 1.7. Counsel Lomesh Kiran also would adopt the submissions made by the senior counsel KJ Raghavan and senior counsel Sergeant Puvaya and Dhyan Chinnappa. The same is placed on record. Yes. Yes.
Sorry for inconveniencing the court, Dharwad, Bangalore.
No, that's all right. No problem. Yes. 27th.
Very please.
Yes.
My lord, the fact that 1.32 will be heard separately, my lord.
That
will
will
be
be
recorded.
The learned counsel appearing for the petitioner 1.32 only submits that the issue in the list is not akin to what is connected, and will have to be heard separately, which is not disputed by the respondents. In that light, serial number 1.3 to number Harpatu, the same would be heard after the conclusion of the hearing of all the other cases.
Grateful.
Grateful.
Yes. Yeah. Make it the
No, he's not raising.
Okay.
They gave an extra one.
Jewel. 2020. Yes. Very cases.
Being spoken to still number 2.
ಇವತ್ತು ಸಾಯಂಕಾಲ ಮಾಡ್ತೀವಿ. Today evening I'll release.
ಅಲ್ಲ ಅದು A7 ಕೂಡ ಕ್ವಾಶ್ ಆಗ್ಬೇಕು ಅದರಲ್ಲಿ.
Yes. ಇಲ್ಲ ಇದೆ ಕುಡಿ ಸಾಯಂಕಾಲ ಮಾಡ್ತೀವಿ. Yes.
Order still number 3.
Senior counsel is coming. That's all.
Coming where
He's just honest.
and when?
No, please. Pray for a short accommodation. If they are completing, I do not have
One
any.
ನಿಮಿಷ offense ಏನು?
424.
420?
420. It is a charge sheet file, my lord. They are question for.
So
a
what?
charge sheet. They have filed a propositions, my lord.
Proposition.
Propositions and synopsis on the last
Oh,
date of
the
hearing house.
ಆಯ್ತು.
And the FIR, in the FIR stage, it has been dismissed with this honorable court by lordship.
Dismiss ಅಥವಾ withdrawn?
Withdrawn.
Because withdrawn.
Withdrawn.
Lot of difference.
Yes, I'm sorry. So basis on that, my lord, if they are completing today, I do not have any objection, my lord. But I have applied for some documents from the CBI and the local courts, even with the police under RTA, because police are also denied to give the documents. And the Lordship also has directed the registrar.
Pass over, madam.
Much of it.
Next.
Number 4.
Respond number 2.
ಏನ್ modify, ಯಾರು ನೀವ್ ಹಾಕಿದೀರಾ?
We have only filed an application, my lords, because what has happened is your lordships had dismissed the matter and given a time frame within which the trial had to be completed. However, my lords, this matter, the prosecution had filed an application under 173 subclause 8. Now they had to file additional charge sheet. The lordships had directed Jagdish sir to seek directions, my lords.
Let him come, pass over.
Five.
And for the hearing either.
Being spoken.
ಅಲ್ಲ ಇಂಟರ್ಲೋಕೇಟರ್ ಅಂತಿದೆ. ಇದು ರಿಲೀಸ್ ಮಾಡಕ್ಕಷ್ಟೇ. ರೆಡಿ. ನೋ ಫರ್ದರ್ ಆರ್ಡರ್ಸ್.
6.
Requesting for extension of parole, my lords. This is the same dialysis case.
What case? Dialysis.
Dialysis case, my lords. He suffered a cardiac arrest on 7th of October. The condition has
Yes,
worsened.
Jagdish sir. Earlier order ಇದೆ.
It's at page annexure B, page 10.
JY. Extension. ಎಷ್ಟು ದಿನ ಕೊಟ್ಟಿದ್ದು ಮುಂಚೆ?
60 days.
302.
138. 138.
ಅದೇ ನೀವು ಪೆನಲ್ಟಿನೇ ಮುಗಿಸ್ಬಿಡ್ತೀರಾ? ಏನು ಉಳಿಯೋದೇ ಇಲ್ಲ.
Condition is helpless.
What condition? 60 days. All right. Same.
Apologies for interruption, my lord, but in that serial number 1, the interim order has to be extended.
1.32 ಅಲ್ಲಿ interim order. ಅದು ಯಾವ್ದ್ರಲ್ಲೂ ಎಲ್ಲಾದ್ರಲ್ಲೂ in all the cases there is interim order. Make a common. ಅದು 1.32 separate ಮಾಡಿಬಿಟ್ಟು ಇದನ್ನ ಎಲ್ಲದಕ್ಕೂ common order. Interim order subsisting will continue. That's it. Yes, next.
7.
Parole.
Extension of parole.
Which is this? That.
Yes.
ಎಷ್ಟು ಕೊಟ್ಟಿತ್ತು ಮುಂಚೆ?
90 days.
Another 90 days.
Eight.
Extension of interim order, vacating stay. Modification na.
ಅವರು ಹಾಕೊಂಡಿದ್ದಾರೆ.
Hearing
an application for that ಮೇಲೆ ಅದು ಸೂಟ್ ಹ್ಯಾಸ್ ಟು ಗೋ ಅಂತ ಹೇಳಿ ಅದರಲ್ಲಿ your lordship's observation ಇಲ್ಲ ಅಂತ ಹೇಳಿ.
This is a suit for rejectment.
Vacating ಇದು ಆರ್ಗ್ಯುಮೆಂಟ್ ಬರುವಾಗ ನಾನು I could not.
Vacating will ಯಾಕೆ ಬರುತ್ತೆ? Let it go before the regular court.
My lordship's order, my lords, if my lords could.
What is modification, Keshav?
The only modification is the pendency of the present petition will not come in the way of the trial court proceeding with the matter is the only relief that I'm seeking.
Which proceeding it will not come in the way of which proceeding?
Trial court proceedings, my lords.
Interim order iddu, how can that be done?
My lords were pleased to not extend the interim order on the previous date of hearing.
I have not extended, is it?
You have not, my lords were pleased to not extend.
I was not present.
For the only reason, my lords, for the only reason because they are setting up a
regular court.
Please.
There is no warrant of any modification of the order. Post the matter before the bench having roster. Yes.
Interim order to continue.
Yes, whatever order. Yes, next.
Continue.
Yen barnide next.
9.
An application, my lord, it has to be posted, my lord.
Alle,
please
let you go before the same court.
Please,
yes.
Please.
Next.
9.
Yes, sir.
I'll commence on the.
ಮುಗಿಸ್ಬಿಡಿ.
ಮುಗಿಸ್ಬಿಡ್ತೀನಿ.
ಇವರಲ್ಲಿ ಪ್ರಸನ್ನ ಕುಮಾರ್. ಯಾರಿಲ್ಲ. ಆಯ್ತು, ನೀವು ಶುರು ಮಾಡಿ.
Lordship, kindly have a look at the batch of appeals.
Now, you are only on one issue, clubbing.
Yes.
Yes.
Kindly have a look at the total number of appeals which have filed. ಅದರಲ್ಲಿ ಒಂದು statement ಕೊಟ್ಬಿಟ್ಟಿದ್ದೀನಿ.
ಆಯ್ತು.
First page ಅಲ್ಲಿ. Because there are 6 appeals before this honorable court and 3 cases pending for trial.
Pending before the court.
Just, my lord, before going to the IA, I'll just give the facts, my lord, that will lead to.
Yes. Before that, my lords, may I submit? My lords, they filed an application for seeking stay of conviction.
No, that I will not press now because I am arguing.
No,
on the
it's
other
on
issues.
merits, clubbing, which, where is Prasanna Kumar?
My lords is on to Chennai, my lords.
Allu argue ಮಾಡಕ್ಕೆ
ಅಲ್ಲ ನಾನು ಮಾಡ್ತೀನಿ ಟೈಮ್ ಬೇಕು at least 1-2 hours ಬೇಕು.
You may make notes. I'll post it on a day when Prasanna Kumar is there.
Please.
Notes. He's gone on the merit of the matter, conviction.
Because they filed an IA for seeking stay of conviction, for
ಅಲ್ಲ,
which
ಅದು
we
ಇನ್ನೊಂದು
have
ಕೇಸಲ್ಲಿ
then objections for approval, which will
ಅಲ್ಲ ಅದಕ್ಕೆ objection
may be taken up together in that case, my lords.
You make notes. Yes. Because
But
this
kindly
was
have a
fixed.
look at this,
This was fixed.
list.
Date was fixed. I can't come here every time. Yes. Next.
List of cases which I have filed. My lord, special CC 53/2004 because ಇದರಲ್ಲಿ ಏನಾಗುತ್ತೆ ಅಂದ್ರೆ I am appearing for the public servant. Public servant is common in all the 9 cases. And exporters and stevedores, there are difference. ಅದಕ್ಕೆ ಒಂದ್ಸರಿ ಯಾವ ಕೇಸಲ್ಲಿ ಯಾವಾಗ ಅಕ್ಯೂಸ್ಡ್ ಅಂತ ಕೊಟ್ಬಿಟ್ಟಿದೆ ಒಂದ್ಸರಿ ಅವ್ರ ಹೆಸರುಗಳು ನೋಡ್ಕೊಂಡ್ಬಿಟ್ರೆ that will be easy for
page
ಫಸ್ಟ್ ಪೇಜ್ ಅಲ್ಲೇ ಇದೆ.
ಆಯ್ತು.
ಸ್ಪೆಷಲ್ 53 ನಲ್ಲಿ A1 is Mahesh Bidia, Lakshmi Venkateshwara Mindal is the firm, the owner of the iron ore. Then Mahesh Kumar is the proprietor, and Mallikarjun Shipping is the copy. Mallikarjun Shipping is the steward person who gives the steward services. But in all these cases, Mallikarjun Shipping, Satish Sail, and Mahesh Bidia are common accused, and other accused will change. The other facts that will change is the heap numbers and the quantity. The rest of the things are common.
Now these trials are not clubbed and taken together?
It is not clubbed and taken together. That is exactly my argument. Let kindly have a look at the first 6 cases. There I have given the appeal numbers also. Next column. These are concluded where Satish Sail is the accused because of the fact that he was an MLA.
It goes before the special.
It goes before the special court. And other 3 cases are before various different courts. Let the serial number 7, which is under trial, there also the allegation is exactly same. I have produced the charge sheet. The one factor which your lordship could notice is the case number 9, where there are 3 additional accused. But Green Text Mining is the first accused. Ajay Karbanda, the proprietor, is the second accused, and Mahesh Bilia, port officer, is third accused. And Captain Swami is the port officer again. Narendra Hital Mukhi is the forest officer, and Chandrakant Govind Naik is the forest officer. Kindly have a look at page number 63.
All right, it is admitted that parties are common.
Yes.
And several facets.
No, 3 of them are common.
3 of them are common.
There are other different accused, but the basic difference
No,
I would like to point out.
What is your ground for clubbing?
Clubbing, my submission is, I am on this as well. It is a single conspiracy, common object, common place of offense. That is the 3 criteria for ಕೊಟ್ಬಿಡ್ತೀನಿ ಸರ್. ಅದ್ರ ಮೊದಲು ತಾವು ಸ್ವಲ್ಪ 3 ಮಹಾಜರ್ ನೋಡಿದ್ರೆ ಆಮೇಲೆ ನಾನು ಜಡ್ಜ್ಮೆಂಟ್
Instead of the parties, take me to the Mahazar.
Lakshmi, kindly have a booklet in
page
special CC number 11 ಅಂತ ತಗೊಂಡ್ಬಿಟ್ರೆ
page
ಆ ಬುಕ್ಲೆಟ್ ಅಲ್ಲಿ ಇಲ್ಲ ಪೇಪರ್ ಬುಕ್ ಇದೆ ಬೇರೆ because that booklet I have given for addition.
Paper book in
criminal appeal number 2082 ನಲ್ಲಿ
2082. Yes.
ಅದರಲ್ಲಿ ವಾಲ್ಯೂಮ್ 3 ಸಾರಿ ವಾಲ್ಯೂಮ್ 2
ವಾಲ್ಯೂಮ್ 3
ವಾಲ್ಯೂಮ್ 2 most of the documents are common in all the cases. ಅದರಿಂದ ಸರ್ಟಿಫೈಡ್ ಕಾಪಿ ತೆಗೆದು 6 cases ಅಲ್ಲಿ ಸೆಪರೇಟ್ ಆಗಿ ಮಾರ್ಕ್ ಮಾಡಿದ್ದಾರೆ. And mergers are common, FIR is common, even evidence and witnesses are also common. Only convictions are there.
ಹೇಳಿ
First
That is-
FIR.
That is what you had to prepare. See, what is common?
Yes.
Mazar is common. A place of occurrence is common. All those things are common. Where are the legal prepositions?
ಅಲ್ಲ ಅದು ಪೇಪರ್ ಬುಕ್ ನೋಡಿದ್ರೆ ಇಲ್ಲೇ ತೋರಿಸ್ಬಿಡ್ತೀನಿ ನಾನು. ಅದಕ್ಕೆ ಪೇಪರ್ ಬುಕ್ ಕೇಳಿದೆ ನಾನು. Because it will, since it is an appeal, it will take little bit of time. ಪೇಪರ್ ಬುಕ್ ಅವ್ರು ಕೊಟ್ಬಿಟ್ರೆ ಯಾಕಂದ್ರೆ ಫ್ಯಾಕ್ಟ್ಸ್ ಅಲ್ಲಿ ಒಂದ್ಸರಿ ಹೋಗ್ಬಿಟ್ರೆ ನಾವು ಆಮೇಲೆ ಕ್ವಶನ್ ಆಫ್ ಲಾ ಎಲ್ಲ.
No. If the appeal had to be heard whole hog,
No.
it's a different.
I am not on that.
Now you are on clubbing. Now, so you concentrate.
I will to multiple.
ಇದೆಯಾ madam?
ಪೇಪರ್ ಬುಕ್ ಬಂದಿಲ್ವಾ?
ಬಂದಿಲ್ವಾ?
Because that is one truckload ಇದೆ.
Yeah, that's correct.
Each case has 11 volumes.
That's why those prepositions you prepare ಮಾಡ್ಬಿಟ್ರೆ.
Okay.
See, you prepare the prepositions on clubbing, then you indicate the page numbers in the paper book with regard to those clubbing, reasons that you are submitting for clubbing, then provision of law, judgments.
ಒಂದು ಪೇಪರ್ ಬುಕ್ ಕೈಗೆ ಸಿಕ್ಕಿದ್ರೆ ಇಲ್ಲೇ
ಅದು ಮಾಡಿ ಒಂದು ಪೇಪರ್ ಬುಕ್ ಕೈಗೆ ಸಿಗ್ಬೇಕಲ್ಲ ನೀವು.
ಏನಾಗಿದೆ ನಾನು ಸೆಪರೇಟ್ ಕೊಡೋದಕ್ಕೆ ಹೋದ್ರೆ ಈಚ್ ಕೇಸ್ ಅಲ್ಲಿ 11 ವಾಲ್ಯೂಮ್ಸ್ ಇದೆ.
ಈಚ್ ಕೇಸ್ ಅಲ್ಲಿ 11 ವಾಲ್ಯೂಮ್ಸ್ ಇದೆ.
Then I will prepare
compilation ಮಾಡಿ ಕೊಟ್ರೆ
ಕೊಟ್ಬಿಡ್ತೀನಿ.
it will be easy for them, easy for me to decide on only on that issue.
Only on that
because CV Nagesh sir ನೀವು ಹೇಳಿರೋದೇನು it's only on that issue.
Yes.
So concentrate on that. In if you make it very easy.
Lord, I'll just narrate the background. Lord, what transpired?
No, you should give spiral ಮಾಡ್ಕೊಡಿ ಆಮೇಲೆ narration.
Ready ಮಾಡ್ಕೊಡಿ.
Yes, you should have been ready with that now.
Ready ಮಾಡ್ಕೊಡಿ.
So ಅವ್ರಿಗೆ ಬೇಕಾಗಿರೋದು ಅದೇ.
Yes, ready my lord.
ಯಾವ ಕೇಸಲ್ಲಿ?
2080 Kumar.
ಅಲ್ಲ ಎಲ್ಲದರಲ್ಲೂ he is appearing for Satish Sahil. I am appearing
Who is
for
appearing?
CV Nagesh sir.
The matter was last day the matter was told that we will be taken at 5 o'clock.
5 o'clock?
ಇಲ್ಲ ಅದು ಅವತ್ತು
ಇವತ್ತು 5 o'clock.
5 o'clock ಅಲ್ಲ that common table I will prepare and give it. No, that is no issue.
ಆಯ್ತು ಸೀನಿಯರ್ ಇದ್ರೆ ಅಲ್ಲಿ ಹಿಯರ್ ಸೀನಿಯರ್ ಎಲ್ಲಿದ್ದಾರೆ? 3 o'clock bench ಇದೆ. I'll finish the bench and come back.
I will make my submission, then I will give the common list. One paper book ಕೈಗೆ ಸಿಕ್ಬಿಟ್ರೆ ಕೊಟ್ಬಿಡ್ತೀನಿ.
You should first prepare.
I'll
prepare these propositions, judgments and everything and then come. I'll pass it over.
Please.
Possible madhyana. By 5 o'clock you prepare.
I'll try. ಅಷ್ಟೊಳಗೆ ಪೇಪರ್ ಬುಕ್ಸ್ ತರಿಸಿಟ್ಬಿಡಿ.
ಅದು ಅಷ್ಟರಲ್ಲಿ ನಾವೇನ್ ಮಾಡ್ಬೇಕು ಮಾಡ್ತೀವಿ, ನೀವು ಅದು ಮಾಡೋದು ಮಾಡಿ. ಎಸ್ ಪಾಸ್ವರ್ಡ್ ನೆಕ್ಸ್ಟ್ ಕರೀರಿ.
13.
ಎಸ್ ಇದಾರಲ್ಲ. ನಿನ್ನೆ ಎಲ್ಲಿ ಹೋಗಿದ್ರಿ? ಓ ಎಸ್ ಓಕೆ. you're okay? Jet lag, huh? No, because you had gone to the Supreme Court. Supreme Court has directed it to be disposed before 4/11/2025. If I don't hear, I'm sitting in Dharwad. If I don't hear, then how will I dispose of? ಅಷ್ಟೇ. ಅದಕ್ಕೆ ನಿಮ್ ಬೇಕಾದ್ರೆ ನಾಳೆ ಕೊಡ್ತೀನಿ ಟೈಮ್ ರಿಪ್ಲೈ ಮಾಡಕ್ಕೆ. ಅವ್ರು ಮಾಡೋದು ಮಾಡ್ಬಿಡ್ಲಿ.
My lord should kindly have the order passed.
Your colleague, ನಿಮ್ಗೆ ನೋಟ್ ಮಾಡ್ಕೊಳಕ್ ಆಗಲ್ಲ, ನಿಮ್ colleague ಕೂರ್ಸಿ. Yes.
Order passed by the Supreme Court, if my lord should kindly have it.
That came, I didn't know that order at all. Then chamber when it came, I saw.
In fact, my lords had passed an order staying the proceedings, and there was another order in the connected matter, both of which was challenged before the Supreme Court. Now, Supreme Court has not interfered with the orders, but a request has been done for the disposal of the matter.
Both were, even grant of an interim order was challenged.
How 17/12/2024 criminal petition number 8786 of 2024. That was the interim order. Then there's another order, my lord, 16125 in criminal petition 11726. Both of it was challenged. And this is what the court would say. We're not inclined to interfere with the impugned order, which has rather worked itself out. Taking note of the statement made by the learned counsel appearing for the petitioner,
within a period of 2 months from so and so.
Yes, my lords, I said 2 months.
That's why 411, yes.
So, my lords, the 4 petitions which are before my lords today, serial number 13 is criminal petition 11726 of 24. Now, this is filed by the victim who challenges the bail order granted to A1.
For the other?
First matter, 11726. 11726
This
of
is
24.
Challenging the bail granting order.
Challenging the bail granted to A1. And on behalf.
What's your name? Akshay. Yes, relax.
My lords, in that matter, Leela appears in that matter, first matter, my lords.
Yaudhrali?
11726 of 24 for the petitioner.
That later we will see.
Second,
first come to the main matter.
13.1. 13.1 is 8786 of 24, where A1, my lords, who is the seer of the mud, he has challenged the charge sheet. Third matter, my lords, that's the matter which I will be arguing, my lords, second matter. The third matter, 11808, victim challenges A2's bail order. And the fourth matter, criminal petition 71 of 2025, this is filed by A2 seeking quashment. Now, there are 2 accused, my lords. A1 has filed 1 petition seeking quashment of the charge sheet, and A2 has filed the other seeking quashment of the entire charge sheet. Now, my lords, the main grounds that we have taken, Bhajanlal, illustration 5 and 7, my lords.
Malafide.
One is malified, and other is it's so absurd and inherently improbable that no prudent person would think that it is worth proceeding further with. That is one ground.
No, yes.
Second, my lords, it's manifestly attended with malifieds, where, my lords, it has been done only to spite. That's the ground that has been taken, my lords. And one other aspect is, we will point out, my lords, that the statements that have been given, there's so much of material inconsistency, we can't get a clear-cut version of what the prosecution case is. Because here, my lords, the complaint is given in 2024, where the FIR gets registered. Victim is aged about 20 years when the complaint is given. The informant is the father of the victim. He says he got the statement from the victim, he sets the law in motion. In this complaint, the allegation relates to events that have taken place in 2017 and 2019. This is what the complaint is about, my lords. So 2017 should be a minor, and when she used to go to the mutt, the allegation is that sexual intercourse in the mutt. This is 2017. Same they would say repeated in 2019. After about 5 years comes this complaint which has been given. Now, in the course of this investigation, my lords, her statement is recorded about 6 times. She had a 161 statement on 4 occasions, 164 statement, and her statement recorded during her medical examination. So we have culled it out in a chart, my lords. Each of the statements, as I will point out, my lords, on all material particulars, how there has been various stands that have been taken. Now, to support what she says, we would only have certain hearsay statements of the mother, the father, and a cousin sister. According to us, my lords, the whole object of filing this complaint was at the instance of 2 persons who are working in the MUT, who are CW6 and CW7. They are the persons who would instigate such a complaint to be given. The reason being, my lords, there was an FIR registered against them. 4 FIRs would be of relevance, my lords. If my lords should have page 15, my lords have prepared a whole synopsis. I'll go about it in terms of that synopsis, which will make it much easier, my lords.
Our copy kottidera?
Howdu, last time koಟ್ಟಿದ್ದೀವಿ. Can I complete my whole narration?
Let him finish.
It will take some time when I narrate.
ಅದಕ್ಕೆ ಹೇಳಿದ್ವಿ, relax and rest.
My lords, page 15 in that compilation may be noticed. 4 crime numbers that were registered. The first of the crime numbers, crime number 14 of 2024, the informant is accused number 2 in the present case. Abhilash, he gives a complaint against Abhishek, who's CW6, and Nandesh, CW7. There was an attempt made for extortion, my lords, on the basis of saying we will circulate in social media certain contents which may be detrimental to you. That was the threat given. On that basis, this FIR was registered. Now, on investigation, my lords may notice the status there. It is shown as pending investigation. Page 15, Ali, my lords, 15.
Yes, oh, chart illidiya.
Yeah, tell you that. Because in that last column, we had put it as pending investigation. But now, my lords, a B report is filed.
In their favor.
In their favor, B report filed. And my lords, wakalat has been filed, but there's been no sitting, so objections haven't been yet filed. But B report is not yet accepted. That's the present status of the first case. There, my lords, second case there, crime number 50 of 2025, dated 7/3/2024, is the present set of matters where they allege, my lords, rape. The third, crime number 52 of 2024, my lords, there the informant is a victim. She says, I received certain threats, and that is how that FIR gets registered. We had approached this honorable court in a 482, and there's an order of stay. My lord should have that in column number.
Not connected with this?
No, it's not connected with this. My lords may kindly notice column 4, present status, stayed by this court in criminal petition 6148, interim order dated 2/7. Similarly, my lords, the fourth case, crime number 335, here the informant is CW6. My lords, according to us, the CW6 and CW7 are the cause of this whole thing, my lords. CW6, he would say again there's been threat given against 4 persons. FIR gets registered.
Abhishek and Nandesh.
Yes, my lords.
Who are they?
My lords, they were persons working in the mud. They are the ones, my lords, who first said, if you don't pay us, we will circulate videos on you. That is how the first FIR got registered against them. As a counterblast, my lords, comes the present FIR, which I will point out, my lords, in the terms of narration and what they had to say. So, my lords, these are the 4 FIRs. Yes. Now, the present case, my lords, would have the synopsis, page 1 of the synopsis. My lords may notice the offences alleged, page 1. Offences under the POCSO Act
4, 6, 11 and 12.
12, under the IPC, IT Act, and my lords.
That is in the FIR?
FIR, in the FIR. Second paragraph, charge sheet, if my lords notices, additional charge. Under 67A of the IT Act, 3 of the Religious Institution Prevention of Misuse Act, and section 30 of the Arms Act. My lords, the date of the alleged crime is between 2017 to 2024. Though I will point it from the complaint, they only would say it is 2017, 2019. After that, 5 years later comes his complaint. My lords, place of crime is in the mud itself, my lords, according to them. FIR gets registered on 7/3/2024. Complainant, in fact, the complainant is the father, my lords, but he says, I got the complaint from my daughter. So he produces it before the police station. The victim's date of birth may be noticed, my lords, 28/3/2004, at the time of giving the complaint. So she was 20 years at the time when the complaint is given. There are 2 accused persons named. A1, he's a Purohit in that mutt, my lords. He's also a trustee of that mutt. A2 is another trustee who was always with A1, my lords, for the daily rituals. Charge sheet is filed on 3/5/2024. Page 2 are the offences, my lords, punishment for all the various offences. Now, page 3 may be noticed, my lords, gist of the FIR and complaint. Page 3, right on the top, what's highlighted, paragraph 1 to 5 pertain to incidents of the year 2017, page 5, my lords, and paragraph 6 and 7 of the year 2019.
No,
This period may be very relevant for the.
Right, but when there is so much material, can this court under
I will point
482
out,
examine
my
it and annul the proceedings? That
Yes,
is
my
why you
lords.
should, what are the legal grounds that you
My
are
lords.
wanting to project in a 482 petition?
My lords, legal grounds, I'll still fall back on Bajandal illustration 5 and 7.
Only that?
Ila, my lords, if in this compilation, if my lords would kindly notice in this compilation, page. My lords, page 62 may be noticed, my lords. Where cases of similar natures which have been quashed while exercising powers of 482.
Bhajanlal.
Vandu Bhajanlal, post that, my lords. Page 63. This was a case under 376, my lords. Where quashment has taken place.
Correct.
That was in 2025. Then the third judgment, page 64.
That's an appeal.
It's in appeal. My lord, page 60, say by 64 ಅಲ್ಲಿ ತಾವು ನೋಡಿದ್ರೆ, my lords.
I'm at 64.
Third matter. And in the same one, my lords, fourth criminal appeal. That's a criminal appeal. Fourth matter,
Correct.
fourth case.
Yes. This is with regard to delay.
Yes, my lords. And in our case, I want to highlight the aspect of delay also, my lords. And I will also highlight in the 6 statements how we had varied versions. All that gets covered in these judgments. Now, why a doubt arises about this whole incident, my lords, at the age of 14 and 16, which he says that were incidents that have taken place, human conduct of how it would be at that point of time, my lords, even at the age of 16 and 17. So you would wait for about 7 years to set the law in motion, and without even being able to give details of when exactly what happened. This is how the whole narration goes. So understandable, my lords, if there's some simple variation between 2 versions. This is not so. The variation in the 6 statements, which I have culled out, my lords, in the form of a chart, is of such a nature, my lords, none of this can even be believed to be true, prima facie believed to be true. Now, my lords, the judgments in the end, the last of the judgments there, my lords should get that at page 69, Ishwar Prasad, 2018, 13 SCC, 6122, where it was a case of quashment.
Yes.
So on these principles, my lords, this whole synopsis and the chart that has been prepared. Now kindly notice, my lords, what is the facts that she narrates in the complaint. My lords, the facts she narrates as we were seeing at page 4, my lords. I'm sorry, page 3. Please notice, my lords, the gist of the FIR and complaint. In her complaint, paragraph 1 to 5 pertains to incidents of the year 2017. My lords, would be of relevance because you're giving the complaint after 7 years. And paragraph 6 and 7 of the year 2019. Kindly notice the narration therein, my lords. The narration does not give clear-cut details of what exactly that has transpired. Well, it's paragraph 1 to 5, 1 to 4, my lords, 1 to 4. Kindly notice 1 to 4 of 2017. Her conduct is, my lords, she goes with her parents, and when she's gone with her parents, my lords, ultimately she goes to a room, and that is where she says, my lords, I was subjected to sexual intercourse, and then she comes back and she goes back home. Repeatedly, she keeps going like this between this 2017. 2019 then, same thing she narrates, my lords. Kindly notice Roman number 5 at page 4, my lords, 2019. Same narration that takes place. And page 5, they say they had physical intercourse with her. This is her whole allegation of saying an act of rape that has been committed 7 years and 5 years prior to giving the complaint. One incident of 2024 they mention. My lords should get that at page 5, Roman number 7. A phone call which she received. 2024. January 2024, 15/1/24. After she receives a phone call where they say, bring your cousin sister along, is when she says she's given the complaint. My lords, investigation takes place. We have about 70 charge sheet witnesses. But most relevant would be only 4 charge sheet witnesses in my respectful submission, starting with the victim, my lords.
Now you tell me.
Now the victim.
If I can go into all this in a 482 petition.
Can, my lords. If the worship, from the judgments, I will show from the judgments which I've given, the 6 judgments that I've given, it will cover the issue, my lords, where in a 482, if the court feels, my lords, one is the aspect of delay. One is the aspect of saying whether.
Delay is one thing.
My lords, one is the aspect of saying, reading the entire charge sheet, believing it to be true, whether the ingredients are there or not. I will point that out also, my lords, because Bhajanlal, one of the aspects that he deals is that here, my lords, we would not even get a single instance of saying what was the nature of sexual assault on her. We don't get it at all. Now, kindly notice, my lords, complainant, I've said that there were 6 versions given by the complainant. Please notice the chart that we have prepared on the 6 versions. Page 43 may be noticed, my lords.
Yes. Yes.
Please notice the statement. 7.3 is a complaint which was given to the police. My lords, even the page numbers I have mentioned there. Page 33 is that. 8.3, the next day comes her 161 statement. The third statement.
7.3, 2023 and
my lords, 24. I'm sorry. 24.
24 other?
24. Sorry, my lords.
All right.
8.3, the next day is her 161
You're
statement.
saying next day. 23, 24. Yes. Yes.
My lords, 8.3, they record her statement because the father had come and given the complaint. 8.3, they record her statement. 11.3, again, a 164 statement, my lords, which is recorded. 16.3 is her medical examination. I will point out that.
No. In all these statements, is there consistency?
No, there's no consistency. Yes. That is the main thing. I've highlighted it on the basis of contradictions and improvements done in each of it. My lords, the whole case that was built up was incident took place in 2017 and 2019. Then, my lords, medical examination takes place. They would say about 2 years back, she might have indulged in sexual intercourse. That's how they put a date of 2022. Her subsequent statement, my lords, she brings up incident of 2022. To fit into what you get in the medical examination, you start giving statements, changing the whole version.
But that was not the complaint at all.
Complaint is restricted to 2017 and 2019. So, my lords, these contradictions, I put it under the heading of contradictions and improvements as per the mobile phone. The whole thing arises, my lords, in saying he used to call my mother's mobile phone and he used to ask for obscene messages or videos to be sent to him, and it was being sent to him.
Yeah, this Pontiff.
Pontiff used to call the mother of the victim.
Pontiff wanted obscene videos.
Obscene anta, and this from mobile phones, they were sending it to the Pontiff anta. So these versions that we get, my lords.
But Pontiff did not have it anywhere else.
And interestingly, my lords, this mobile phone, so far as the victim is concerned, it's not part of the entire charge sheet at all. And so far as the mother's mobile phone, my lords, which they have taken, the voice samples which has been taken is totally contradictory. It does not have a time frame, nothing in it. When the investigation takes place, my lords, you would subject voice sampling to identify the voice in the mobile phones. Now, my lords, none of it is done. FSL reports are not taken. A charge sheet is filed. But you build up this case on saying that initially everything that happened was build up the case by saying, build up the case. My lords, what they say is, I kept calling, Pontiff kept calling, asking for all this to be sent. So we used to send it. When we used to go there, she used to go into the inner room, and according to her, she was subjected to sexual intercourse repeatedly. This is the events that they say. So in the first thing, my lords.
Repeatedly
Adralitao, first contradiction improvements as regard mobile phones. Please note the contradictions, my lords, in each of it.
Yes.
The first column used to call her mother's phone and would ask her to send obscene videos. First complaint only. Her 161 statement.
He is asking the mother or the children?
Adu clear illa, my lords. Adu clear illa.
The mobile phone is not subject to FSL?
No. My lords, they say it so far as a victim, because there is contradiction in saying whose mobile phone. Some places it comes as though it is her mobile phone. Her mobile phone, she says she's lost it. So that mobile phone is not to be traced. Manege benki biddu hoita. And mother's mobile phone, my lords, as I will point out, is again not subjected to an FSL report. So, my lords, kindly notice in the first it is mother's mobile phone. In the second column, the statement which was taken on 8/3/2024, the bottom portion, I have put it as page.
Adu mother.
Ali kelgade next page barutte, my lords. On her phone anta barutte, next page tav nodidre. So victim's phone. So it changes, version changes. From what was being done to the mother's call comes as her phone. My lord should notice it in the next page.
Third one is no, whose phone, don't know.
Third one, my lords, used to contact her, send her links, but no mention whose phone was used, no specific timeline for this instance. Then, my lords, the continuation
So
is there.
contradiction is one thing.
Yes, my lords. And
Next.
then the fourth, medical record, my lords. She only gives, she visited the MUT in March or April, and in August 2017, A2 tried to sexually assault her. 2017. Then, my lords, in the 5th, 7/4/2024, again she goes back, mother's phone. My lords would get that at column number 5. And column number 6, where a further statement, there's absolutely no mention of any mobile phone at all. These are the contradictions so far as the mobile phone is concerned. Now, at page 45, reasons for visiting the MUT on the date of an alleged incident of rape. We have different versions given here also, my lords. Each version is different. The first version is mother was not keeping well, aunt was not keeping well, and that's why they all visit the MUT. This was in 2017. Then the next day when her statement is recorded, my lords, she says her hand was swollen. She would go to visit the MUT. The third version, mother was admitted to the hospital and then they suggested a puja, they go to the MUT. Third version. Then, my lords, in her medical records, nothing spelled out why they went there. Then the next two versions, no reasons attributed.
Yes.
My lords, the change in timeline regarding the incident of the alleged rape, my lords would get it at page 46. Every version is different, my lords. First version, 2019, which we get in the complaint. She doesn't remember the exact date. Please notice the second version, my lords. Date changes from 2019 to 2022. My lords gets that second version at page 46. Third version, no date attributed. Fourth version, my lords, medical records, we don't find any date being fixed. The fifth version, she brings it up to June 2022. And the sixth version, 25/4/2022. Now, these are the versions we get. So, my lords, if it is going to be 2022, my lords, probably she's come close to attaining 18 years of age. If it's 2022. But if it is going to be, my lords.
We'll continue. I'll come back at 2 o'clock.
Please.
So there's a bench at 3 o'clock. Between 2 and 3, what is possible we'll do.
Yes.
Rest after the bench. Matter ಯಾವುದು? ಇದು ಕೇಳಿದ್ದೀನಿ ತಾಳೆ. ನೀವೇ ಮಾಡಿ ಕೇಳಿದ್ದೀನಿ ನಾಳೆ.
My lords, one indulgence, my lords, one submission. Serial number 15, my lords, I appear for respondent.
Yes, sir.
My lords, it may kindly be, I may be given some accommodation, my lords, personal.
All right.
Let's appear for respondent one, my lords. Let's
Next week?
appear for respondent one in the. Let's
Learned counsel Shivraj and early 6. A week's time, is it?
Oh, please, my lords, 1 week.
A week's time. Let's the matter on 31st. Interim order subsisting will continue to the next date.
Am I audible, my lord? Sorry, my lords.
Any other adjournments? Yes, Shankar?
Serial number
11,
15, my lords.
adjournment Becca.
My lord, serial number 15.
1 minute, page wise correct body, madam. 1 moment.
My lords, with your kind leave, a memo for posting, my lord.
Posting.
It was a further hearing matter, my lords.
Eaga.
If it may be heard tomorrow, my lords, there's emergency.
Emergency? Could he further hearing have emergency note?
Serial number 18.
1 ನಿಮಿಷ, page wise.
Page wise. Page 12.
ಅಲ್ಲ ಇದು 4 ಏನೋ ಅಂದ್ರಲ್ಲ ಇವರು ಮಯೂರ್
4 passport.
ಹ್ಮ್ 31st ತಗೊಳ್ಳ ಜಗದೀಶ್ post 10th ಅಂದ್ರೆ it would be 14th 14th, yes, at the request of the respondent, second respondent, list the matter on 14th November. Interim order subsisting will continue to the next. Yes. Next. Correct body, madam. Page wise. Pass over agida. Barli Sunil Kumar.
Page 12, seal number 16.
7 point.
Appeals.
1 ನಿಮಿಷ 11 point of criminal appeals ಎಲ್ಲ ಇದೆ ಅದೇನು don't take adjournment in that. No, wait, yes. No, wait. 16.
Told that senior would come at 2:30, please.
ನಿಮಗೆ ಟೈಮ್ ಬೇಕಾ?
ಇಲ್ಲ, ಬೇಕು, ಇವತ್ತೇ ಇರಲಿ.
ಇದು ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಡೈರೆಕ್ಷನ್ ಇದೆ, ನಾವೇನು ಅಡ್ಜರ್ನ್ ಮಾಡ್ತಾ ಹೋದ್ರ ನೀವು ಇದ್ರಲ್ಲೂ ನೀವೇನಾ? ಹೌದಾ? ಇದು ಪೋಕ್ಸೋ. ಸರಿ ಆಯ್ತು, ಮಧ್ಯಾಹ್ನ ಇಲ್ಲ ನಾಳೆ ಮ್ಯಾಕ್ಸಿಮಮ್. ಯು ವಾಂಟ್ ಗೋ ಅಂಡ್ ಸ್ಲೀಪ್ ಅಂಡ್ ಕಮ್. ನಾಳೆ ಬೇಕಾದ್ರೆ ತಗೊಂತೀನಿ ಬಿಕಾಸ್ ಜೆಟ್ ಲ್ಯಾಗಿಂಗ್. ಸ್ವಾಮಿ ಅದು ಇವತ್ತಿಲ್ಲ ನಾಳೆ ಮ್ಯಾಕ್ಸಿಮಮ್.
Chance in the afternoon.
Afternoon after completion of division bench, or I'll come back at 2 o'clock. 2 o'clock ready idre 2 o'clock. Yes. Iviri hengo idu nadita idiyalla iri. Yes.
Page 13, 18 and 19.
No, 18 is a matter, my lord, relating to an construction of a commercial complex in Sarashiv Nagar.
Puttu.
Lordship will take it up.
We'll take it. Yes.
Wait.
18 Yes.
19 may.
No, after division bench I'll come back. 6:30 also I'll take it. Yes.
19. I'm appearing in 19. Lord, we may need some time.
19 time ಬೇಕಾ? ಆಯ್ತು, we'll see.
Not a short issue at all. Don't say short. It has a history of almost 10 years.
All right, we'll see. ಮಧ್ಯಾಹ್ನ ಆಗಿಲ್ಲ ಅಂದ್ರೆ we'll adjourn it.
Page 14, 20,
18.1. 18 ಕೇಳಿ wait. Yes. Adjournment and better. Next.
Page 14, 20 to 22.
Sir.
21, my lord.
Acquisition.
Yes. By tomorrow, or if it is
fruits and vegetables.
Pardon me? Fruits and vegetables.
Yes, sir.
And rules of next generation has to be protected.
Correct.
Next generation has to
otherwise
be
fruits and vegetables won't be there. Yes.
ನಾಳೆಗೆ tomorrow ಆಯ್ತಾ?
ಇಲ್ಲ ಇರ್ಲಿ, ಮಧ್ಯಾಹ್ನ ಆದ್ರೆ ಇಲ್ಲ ಅಂದ್ರೆ ನಾಳೆಗೆ.
ಅಂದ್ರೆ ಹಿಯರಿಂಗ್ ಏನೋ ತುಂಬಾ ಇದ್ವು ಅನ್ಕೊಂಡು ಅಷ್ಟೇ.
ಇಲ್ಲ, ಅದೇ ಆಗೋ ಕಾಂಪಿಟಿಷನ್ ಕಮಿಷನ್ ಆಯ್ತು. ಸೊ ಮೈನ್ ಥಿಂಗ್ ಇಸ್ ಓವರ್. ವಿಲ್ ಸಿ ಆಫ್ಟರ್ನೂನ್. ದೇವದಾಸ್ ಸರ್ ಯಾವ್ದಕ್ಕೆ ಕಾಯ್ತಿದ್ದಾರೆ? ದಟ್ ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಿದ್ದೀರಾ? ದೆನ್ ವಿಲ್ ಹಿಯರ್ ಇಟ್. ಆಯ್ತು, ಮಧ್ಯಾಹ್ನ 2 o'clock I'll come back. Whatever is possible we'll do up to 3 o'clock. 3 o'clock bench ಇದೆ, ವಾಪಸ್ 4:30 I'll come. Yes. In a 22 is yesterday's matter, sir. We'll continue. Yes.
Because before my lords, before vacation.
ಯಾವ್ದು ಕೊಟ್ಟು ಇವತ್ತು ನಾಳೆಗೆ ಆಗಲ್ಲ, ಧಾರವಾಡದಲ್ಲಿ ಬರ್ಲಿ.
Serial number 3 ಪಾಸ್ ಓವರ್ ಆಗಿದೆ. Date may be given.
ಅವರು ಟೈಮ್ ಕೇಳ್ತಾ ಇರಲಿಲ್ಲ, ಎಲ್ಲಿ ಇದ್ರಲ್ಲ. 7th November ಹಾಕಿ ಮಾಡಿ.
Entry model.
We'll come back at 2 o'clock.
ಎರಡು ಗಂಟೆಗೆ ಕರೆದ್ಬಿಡ್ತೀನಿ ಫಸ್ಟ್ ವೇಟ್ ಮಾಡಿ.
ಸಿದ್ದು ಅಣ್ಣಿಗೆ ಕೊಟ್ಬಿಡು.
Promise to marry there. Mayur?
Yes.
Promise to marry?
Yes, Manoj.
This has become final?
Yes, Manoj.
This court, in terms of its order dated November the 20th, 2024, allowed the petition, quashed the proceedings, quay the petitioner on the score that it was an abuse of the process of the law. They said the judgment rendered on 20th November 2024 has since become final, is a submission made by the learned counsel for the petitioner. The petitioner has now filed an application seeking masking of the name of the petitioner in the light of the quashment of the proceedings. The issue as to whether the name of the accused could be masked on conclusion of the proceedings in favor of the said accused is considered by this court in so and so. My judgment is that Abhinaya Keli.
I've extracted in the application as well.
Yes, so and so. In the light, this court, considering the identical circumstances, is held as follows. In that light, the application deserves to be considered and allowed with a direction to the registry in LA.
Yes, Manoj.
With a direct, LA the application. LA the application.
It's filed today, Manoj. It's already brought on record, Manoj. There's an implement application and an application for
Implement yarige.
Registrar General, Manoj, because they will have to be made a party in case this orders to be passed.
Implement interim helbakagutte. I will dispose it directing the parties. Therefore, the name of the petitioner shall remain masked in the website of this court and Inyadralli
Lord India Kanun, Manoj.
and India Kanun in the India Kanun and Theliri. Yes, ordered accordingly.
Grateful. Lord, serial number 4, your lordships are directed to be listed on 14th. Maybe taken up on 12th, my lords, kindly. I have another matter. Grateful.
14th, 12th.
Grateful.
Lords have said page 46, my lords. Change in timeline regarding incident of alleged date of rape. That's one aspect I may kindly clarify, my lords. This complaint which has been given on the basis of which the FIR is registered. My lords, page 19 is the FIR. It appears that it has been given by the victim herself, my lords. I was under the impression father got the written complaint, but here it appears she herself has given it, which will assume some more significance because the next.
She is the complainant.
Yes, my lord, because the next day a changed version. So, my lords, if it is her who is a complainant who has signed.
Morning you said it was a hearsay in the sense the mother or the father.
Father gave a written complaint, but my lords, from what I gather now, my lords, in the FIR, the signature is hers. The complaint also contains her signature.
You respondent madidira. Second respondent.
Now, in that context, my lords, the complaint would assume that much more significance, where very clearly in the complaint 2017-2019, very clear. The next day, my lords, her 161 statement which is recorded, she changes her version. Now, why this change of version is, my lords? She brings it up to 2022, and she probably with the intention of having the POCSO Act attracted, they would say 2 months before my birthday on that day. So you still remain under 18 years and you say, but the versions, how it keeps changing, my lords, whether it inspires confidence for even a charge sheet to be filed on such varied versions.
The same way, whether it would inspire confidence to quash it on
I will
such
point it out
disputed questions
yes,
of fact.
My lords was pleased to ask, do we have case laws where 482 has been exercised?
Except Haji Ali.
My lords, in this, everything is 482 except one case. I will show it. But why it shows as appeal is, my lords, SLP admit ad nantar it becomes an appeal. But all those are 482s. So specifically, my lords, the compilation which we sought to do were cases where high courts had refused to entertain it under 482s. But Supreme Court said high court was wrong. They should have entertained.
Those were also cases of 376, correct? 16 years, 34 years. Complaints registered after such a long gap, unexplained delay. Now,
some of them, others,
now
my
here
lords.
it is 7 years and 5 years.
My lords, 7 years. My lords, it's not a short gap, my
No,
lords.
that's that there it did not include, or the victim was not a minor. Here the problem is victim is a minor.
When a victim is a minor, please notice this, my lords. 2017, minor. 2019, she continues to be a minor. My lords, she is going along with the parents to the mutt in question. She would come out from the mutt, no complaints of any kind at any point of time.
That will consider.
After about 5 years, my lords, you would say, at that point of time, I felt scared, but now I want to give it. At least you must be specific in the details of what you give. Now, if you have 6 different versions that are given, my lords, we are dealing with a case where its allegation is that of rape, my lords. It can't be taken in a manner where a person can be prosecuted with such varied kind of versions. So that is the reason, my lords, when we prepared this chart, page 46, please notice, my lords, the timeline, how it changes for the purpose of an act of rape. If your first version is 2017, then you say next version it was 2022, 5 years later. Can it be believed, my lords? Prima facie, because we are going to be entering into the stage of a trial later, my lords. Now with this, could a charge sheet be filed is what the court would notice. My lords, page 46, kindly notice first version.
report agಬೇಕಾಗಿತ್ತಾ?
ಆಗ್ಲೇಬೇಕಾಗಿತ್ತು. My lords, I do understand normally when the FIR comes as 376, very rarely they file a B report. They don't want to take it on their.
Coupled with POXO.
How?
4, 6, 11, 12.
My lords, I will point out, because in my notes I've said none of those provisions apply. There's not even a single averment of any penetration. Kindly notice, I will show it. My lords, ingredients I will show
4
it.
will not apply.
My lords, I will show.
You wait, sir. ಏನಾದ್ರು ಇದ್ರೆ ಕ್ಲಾರಿಫಿಕೇಶನ್ ನಾನೇ ಕೇಳ್ತೀನಿ.
Let me
6 ಇದೆ, 10 ಇದೆ, 11 ಇದೆ.
Let me point out from her version what is it that she has stated.
You don't worry, ನಾನು ಡಿಕ್ಟೇಟ್ ಮಾಡ್ತಾ ಇಲ್ಲ ಆರ್ಡರ್ ಈಗ. ಮತ್ತೆ wait.
So kindly notice, my lords, 46, there's 6 versions that I've pointed out. Now the medical report, my lords, which has been given, medical report when she's examined in 24, they would say 2 years back. So which means 2022. So the versions which are given of 17, 19 fade to the background. Now all they would say is 2022, and it could be a case of rupture of hymen. She's reached the age of 20 at that point of time. Now for that, my lords, is one decision which we'll point out. My lords would be quite aware insofar as rupture of hymen, it need not be necessarily attributed to an sexual act. Now, my lords, with that, please notice at page 47, mention of 6 and 7. These are the persons, my lords, according to us, who would get all this done, because there was complaints given against them. As a counterblast to the complaints come this complaint, page 47, we have pointed out how we have different versions of when the victim would have seen CW 6 and 7. Again, different varied versions. They are persons who are working in the mud. And the way she narrates at some places, they said, no, you should go and complain to the police station. When? 2017. So you wait for about 7 years to go and give a complaint. So those discrepancy, my lords, should get at page 47, my lords. My lords, I will not read it, but each of it has a different version to it. Now the grounds that we have taken, my lords.
Ground is, one is delay.
My lords, page 59 for a minute may be noticed, my lords. This CW 6 and 7.
No grounds andre.
Just this one portion, if my lords would notice. 6 and 7, 1 to 5 may be noticed, my lords. And I've extracted the statements. In the first 2 columns is CW6, varied version, 2 statements. Column 3 and column 4 is CW7, varied version that we get insofar as he is concerned. With this, my lords, where is those points? And there's 6 points are done.
Grounds alle.
I'll just point it out. Points for consideration. It says points for consideration. check in the book. There is one point for consideration why the versions are varied. Yes, my lords. Page 11 may be noticed, my lords.
Ground, sir.
How? Page 11.
Points for consideration.
Otherly, page 11, kindly notice, my lords, we have extracted the 70 witnesses. Of the 70 witnesses, my lords, initially page 5 is a victim, page 6 mother hearsay, father hearsay, cousin sister hearsay, page 6 ali. Aunt hearsay. Then, my lords, 6 and 7 is what I pointed out, these two persons, my lords, Abhishek and Nandish. Then from 8, they show it as eyewitnesses. They're not eyewitnesses, my lords. Just in the chart sheet, it is shown as eyewitnesses. 8, 9. Then after that, my lords, really not of great significance from CW 10 to CW 70. Page 11 may be noticed, my lords. Voice recognition Panchanama. My lords, no mention of any time, date, nothing. Voice samples are not of relevance, no FSL report which has been submitted. Even, my lords, despite that, all that it shows is familiarity, my lords. That's all it shows, nothing beyond that, insofar as what they have collected. But in my respectful submission, it should have been an FSL to say that it voice matches with them. That has not been done. So this is insofar as the voice samples are concerned. Medical examination of the witness, my lords, which took place on 16/3/2024, as per the examination report, sexual violence of 2022, 2 years back, very contrary to what we get till there. The final opinion is left blank in the medical records. Page 12, points for consideration, my lords, gets. These are the grounds. Illustration 5 and 7 of Bhajan Lal. My lords may notice the relevant aspect that brings the present case under the ambit of the said illustration, page 12. The complaint is given after about 7 years from the date of the starting point of the alleged crime. No justifiable reasons assigned for this unnatural conduct, and the same defies prudence. Allegations are absurd and inherently improbable. Second, the sequence of the various FIRs disclose that the proceedings is maliciously instituted with ulterior motive at the instance of disgruntled employees, CW6 and CW7. The victim, whose age 20 years at the time of giving the complaint, was not a rustic villager, but was a major and an educated girl pursuing her engineering course. In none of the 5 statements is there any ingredient that could constitute an act of rape as defined under section 375 of the act, where, my lords, penetration, insertion, manipulation or application. Those are the 4 aspects we get, my lords, in 375 as definition for rape. We don't get that in any of the statements. The conduct of the victim would clearly define that her conduct is not in keeping with normal human conduct, wherein she says that the age of 14, when she alleges the incident, she would not inform her parents, her sister, friends, or anyone about it, but then would continue going to the mutt. Periodically, then she narrates certain incidents when she was the age of 16 years. From 2019 to 2024, nothing happens except that one phone call in 2024, which leads to the registration of the FIR. Then, my lords, the victim's allegation seems to be well orchestrated and nothing beyond that. There is no clarity in relation to the date and time on which the acts took place. Because, my lords, when we talk about an allegation of rape, at least some timeline. It can't be very blank statements given 7 years back, 5 years back. It can't be of that nature, my lords.
You mean to say someone who, a victim, would note the time, date?
Date. My lords, for an act of rape, my lords, for an act of rape, if you're not even certain about when it took place, And we're dealing with a lady
The
who's.
complaint is registered immediately, yes. Yesterday, day before, it's 7 years, Alva.
So, my lords, are you going on vagueness, my lords, saying 7 years back it happened, I want to give a complaint now?
Yes.
Consistent with what you're saying, 5 statements you've given. You give different timelines for the 5 statements. Please, my lords, that is one aspect which I have put there. Even the electronic evidence does not point towards any forceful act having any color of sexual obscurity or rape attached to it. It is impossible to swallow the version of the victim that for the entire period of 7 years, she allowed the accused to subject her to physical abuse, according to her, my lords. Believing the entire charge sheet to be true does not disclose the ingredients of the offences. My lords, kindly notice page 13. I have pointed out why it does not have the ingredients of the offence.
Yes.
Page 13, IPC offences, below that POCSO. Then, my lords, on the next page, IT Act, why 67E, 66E and 67A does not come as ingredients. Religious Institution Act, section 3. I pointed that out why it doesn't come. Arms Act, I don't know which.
Both you leave.
My lords, Arms
Religious
Act.
institutions and Arms Act.
My lords, Arms Act, weapon.
IT Act, has there been a transmission of image?
No.
Yes.
So none of it. So I've just extracted that portion of it, my lords.
No, all that is fine. The difficulty is with
Now, kindly notice
4,
the-
6 and 8.
My lords, kindly notice the case laws on this now. What are the kind of case laws Supreme Court lays down to say when the quashment can take place? Please have page 59.
In the Bhajan law.
I'm sorry, 59 Allah. It's going to be 62. I'm sorry, 62. My lords, I will not read Bhajan Lal because my lords has read it a number of times. 5 and 7 is what we have culled out to say illustrations therein. After that, what we have pointed out are cases where high courts had refused to quash matters of rape, which Supreme Court has quashed.
16 years.
Kindly notice 63. Can I just
Rajneesh
read?
Singh is 16 years.
My lords, please notice what they have spelled out there in my lords. Testing the facts of the case, my lords, I'm at 63.
Yes.
On the touchstone of the above precedents, it is clear that the complainant being a highly qualified major woman. Now here we have a 20-year-old lady, my lords, doing engineering. She is qualified. She's not a rustic. And I'm sorry, my lords, both CW6 and CW7, in their statements, they say complaint was given against us. My lords, just as a backdrop to say why this has been, we use the word orchestrated, my lords, why this has been done. They themselves in the statement, they say complaint were given against us. So, my lords, being a highly qualified major woman, continued in a consensual intimate sexual relationship with the appellant over a period of 16 years. Now, kindly take our case, my lords. 2024 is a complaint given. Now, she says from 2017, I repeatedly kept going to the MUT.
Hopefully, consensual acts won't.
Allah,
be a
consensual
protective
Allah.
shield.
Her conduct, my lords.
Allah, conduct, fine, we'll see.
Conduct. From 2017 in the repeatedly you say, I used to go there. Then I used to go inside to the room. I had sexual intercourse there. I have come out. I have gone off. Again, I've gone with my parents. This is the narration that we get. Now, my lords, on human conduct, if really, my lords, incidents of this nature have been repeatedly happening where you've been going, would it be possible, my lords, to wait for about 7 years to set the law in motion? So, my lords, this has certain relevance there. So they say, my lords, in this, the complainant allowing the accused to establish sexual relationship with her over a period of 16 years purely under the misconception of marriage. That is what had happened.
That's promise of marriage.
Now, there is no dispute from 2006. My lords, please have page 64, Suresh versus State of Assam.
34 years.
In this case, yes, my lords, lodging a complaint after 34 years. But what they would say, my lords, they come to category 5 and 7 of Bhajan Lal. My lords, paragraph 14 at page 64 may be noticed. Then, my lords, Haji Iqbal versus State of UP.
Yes.
There's something more to add to the aforesaid, and the same goes to the root of the matter. We take notice of the fact that the alleged act of gang rape in 2018 came to be lodged sometime in 2022, 4 years. My lords, and how she,
Attendant circumstances should be seen.
how she would narrate that is, they would come home and they would lock up certain persons, take her, gang rape her in 2018, complaint given in 2022, 4 years. Now, my lords, in our case, 7 years. If we are looking at the number of years, we do not propose to say anything in regard to delay in lodging the FIR and the trial against the other accused persons. In our own examine, my lords, this whole aspect may be of relevance, and exercise of powers under 482 and 226, paragraph 14 there, my lords, at page 65.
Yes.
Then, my lords, page 66, this was only in so far as that's serial number 5, my lords. My lords, it's on time. I do not. Then, my lords, page 69.
Ishwar Pratap.
Ishwar Pratap Singh versus State of UP, where the court felt they should have exercised powers under 482, quashed the proceedings.
No, that is reiterated.
And, my lords, charge.
That is reiterated even in 2025.
So these are cases, my lords, except, my lords, was please notice where 16 years 34. But what is the principle laid down, my lords? Are such versions to be believed as to be the gospel truth? Which version should we believe? Her first version in the complaint of 2017, her next version of 2022. Which is the version to be believed for us to proceed further, even for framing of charge, my lords?
My version. Yes. Nalena?
It's okay.
Ready? Yeah? Jet lag ilva? Mike, don't worry. No, if you want tomorrow, you take it. No, tondre illa.
I'll finish it today itself. So that,
like, if you want to counter all the submissions that he has made.
yes, I'll just counter those submissions because gradually is misled this honorable court, even from the date of birth. From the date of birth is misled. He says she's 18 years. Date of birth, what he's mentioned in the compilation, my lords, that is only 3 months. It is about 3 months less. If you consider the correct date of birth, she is 17 years. It is not 18.
So when the complaint is registered.
No, when the incident takes place in the year 2022.
Nobody doubts that it is before 18 years.
My lords, my learned friend made that submission.
Senior counsel.
Yes, the senior counsel has made that submission. My apologies. He's made that submission stating that she was about 18 years. Not about 18 years. She's 17 years, 9 months.
Just about 18 years.
Yes. My lords, now that being the case, my lords, he says there are about 5 to 6 versions. I don't know what 5 to 6 versions he is talking about, my lords. My lords, it clearly in the 161, in her complaint and in her 164 statement, she has clearly mentioned when the occurrence has happened. In the year 2022, there is no doubt it has happened before 2022 or in 2017 or 2019. The
complaint says.
No, the complaint also clearly states that 2017 ali nan alli hogak shuru madde anta. She does not say that 2017 they assaulted her. She says that she was inappropriately touched and she was forced into her garbhagudi and touched inappropriately anta heltade.
That is by the pontiff.
By the pontiff. And subsequently, she, my lords, her being a minor, she has been taken to the temple by her parents. She does not go individually to the temple. She's not attending the temple. There's no consensual in that. They have made it look like it's a consensual thing.
Don't get
consensual. Yeah. Sorry, my lords. It does not amount. She goes with her parents. Her parents have taken her at every instance that she has gone to the temple, it is with her mother or her father or with her brother. My lords, what they are claiming that there was that the mother was ill and that is why they went. No, in 2017 she was ill. One of the friend of the father advises them to go to that mutt, and that is where these incidents start happening.
Why illness will become wellness?
No. There is a saying that if some pujas are performed in that temple, there is cure or no belief. It is advised by some third person, and based on that, they've gone to the temple. My lords, now that being said, my lords, my petition, page number 111, my lords.
The bail cancellation.
Bail cancellation. 111, my lords.
Kodi madam, connected matter. Bail cancellation.
My lords, last 3 lines, my lords. She states when the occurrence has happened. ನಾನು ಹುಟ್ಟಿದ ದಿನಾಂಕ 28/6/22ಕ್ಕೆ 2 ತಿಂಗಳ ಮುಂಚೆ, meaning 2022 April. No, I'm trying to show that all these statements are the same. There is no discrepancies or there is no change in any of the versions what learned senior has mentioned, my lords. Next, my lords, page number 115, my lords. My lords, this is the ಮುಂದುವರೆದ ಹೇಳಿಕೆಯಲ್ಲಿ she mentions the date also. She says 24/2022. My lords,
So according to the complaint,
yes,
it is 17, 19 and 22. In 22, she was 17 years and 9 months.
Yes.
Andre, one ನಿಮಿಷ. Yes. 2022, if you say she was 17 years and 9 months, travel 5 years back. Was she 12 years when the first incident happened?
She was about 13 to 14 years is what it is, my lords.
All right. Yes.
My lords, at 164 statement, my lords, at page number 121, she again narrates the same thing. 2022 ರಲ್ಲಿ ನಾನು so and so ಇಲ್ಲಿಗೆ ಹೋಗಿರ್ತೇನೆ ಅಂತ she says ನನ್ನ ಹಾಳು ಮಾಡಿರ್ತಾರೆ ಅಂತ ಹೇಳ್ತಾರೆ. ಆಡ್ ಭಾಷೆಯಲ್ಲಿ ಹಾಳು ಮಾಡಿರ್ತಾರೆ it is the same thing.
ಅದೆಲ್ಲ don't worry.
Yes, there is no, I am only trying to show that there is no version change at all, my lord. She has time and again she has only told in 2022 April ಅಲ್ಲೇ ಆಗಿದೆ ಅಂತಾನೆ she goes on to tell. There also she is mentioned 2 ತಿಂಗಳು ನನ್ನ ಹುಟ್ಟು ಹಬ್ಬದ 2 ತಿಂಗಳು ಮುಂಚೆ ನನಗೆ ಇದಾಗಿದೆ ಅಂತ. It is her trying to show that exactly in the month of April of 2022 this incident has occurred. My lords, and repeatedly they were pointing out to the FSL report, my lords. They say
FSL ilve ilvalla.
My lords, at page number 217, my lords, of my
FSL ಇದೆಯಾ?
217, my lords, kindly.
ನಿಮ್ದ್ರಲ್ಲಿ?
Yes.
Yes. ಯಾವುದು ಇದೆ ಇಲ್ಲಿ?
217 ನಲ್ಲಿ 218, my lords, now page number FSL is 217. 218 ನಲ್ಲಿ seventh column, my lords. Samsung phone, my lords. That is now she talks about that in 161, my lords, at page number 103. She says last line, my lords. Nanna mobile Samsung Galaxy A23 so and so SMA 235 FTS. That is the same mobile phone that has been recovered in the FSL, my lords, at para number 7.
IMEI ನಂಬರ್ ಹೇಳಲ್ವಾ?
IMEI ನಂಬರ್ ಅದು ಮಾಡೆಲ್ ನಂಬರ್ ಹೇಳಿದ್ರೆ
ಬೇರೆ ಎಲ್ಲ ಮಾಡೆಲ್ ನಂಬರ್ ಎಲ್ಲ ಹೇಳ್ಬಿಟ್ಟಿದ್ದಾರೆ. IMEI ಹೇಳ್ಬೋದು.
Model number, my lords, once you buy a phone, it's just a model number. My lords, now in this FSL, my lords, clearly there has been recordings of the video call that the pontiff has done to this victim.
Video call.
Video call agide, audio call agide.
Saying what?
My lords, he requests for some links as well to show herself in the calls as well. My lords, that is present in page number 221, last line. They have taken few words out of his voice calls to the victim here, in my lords. I don't want to read out those specific words. Page 221, my lords. Those words are a little last 2 paras, my lords. For voice analysis, they have extracted a few words that he has requested. This shows that he had actually asked the victim for some links. That word is also mentioned in that para. This, my lords, in the next, they give out an opinion. In that they say the facial features of male individual.
Complaint alli,
yes, my lords.
It says that the pontiff asks the victim to disrobe herself.
Yes.
But this is only a part of the...
Part of that, my lord. Some extractions they have taken out, facial features to match. Mobile extractions. Yes. Some photos have also been extracted. That also has been linked to, my lords. Photos.
Yes.
Photos are also there. They've matched with the photos that are present in this mobile phone of hers. My lords, they give an opinion at page number 222, my lords. The facial features of the male individual present in the above mentioned video file are similar with the respect of facial features of the male individual present in the color photograph marked as D4. The system generated facial features comparison reports are enclosed in a soft copy as annexure A4.
Swamiji.
Swamiji, they one.
Pontiff.
Sorry.
ಕನ್ನಡದಲ್ಲಿ ಯಾಕೆ?
My
ಸ್ವಾಮೀಜಿ ಅಲ್ಲ.
Pontiff, my lords. My apologies. Now, my lords, in that opinion itself, page number 225, my lords, it is detailed even at para number 4. My lords, the comparison of respective voice based on audio and feature extraction methods have revealed that the respective speeches said to be of the male speaker accused, Sri so-and-so, found recorded in the alleged audio files present in the Samsung mobile phone marked as D7A and sample speeches recorded in the audio Mojim SD card marked as D3. The comparison, next para, my lords, the comparison of respective voice based audio and feature extraction methods have revealed that the respective speeches are said to be female speaker so-and-so found to be recorded in the alleged audio file of the Samsung mobile phone D7A and the sample speeches found to be recorded in the audio files of the SD card marked so-and-so. So this links the victim and the pontiff were in communication through WhatsApp, my lords. He used to call her through WhatsApp, through audio calls and video calls, my lords. The photos have also been marked. Can I?
You want to stop?
No, I want to show the audio photos as well.
Really, that
is also marked.
Photo ಎಲ್ಲಿದೆ?
My lords. At 243, my lords, they have done an analysis. 243 to 248 is at A1.
Video call pictures, I think.
These are from the video call. They have still photo, video and the color picture that was given.
This is the pontiff.
Yes.
ಯಾವ pontiff ಇವರು? I 376 POCSO. The other offences, IT Act or the religious what's that act? Adella baralla.
My lords, religious, why it is that, my lords, all of this
Arms Act,
in the
Arms Act ಯಾರಿಗೆ ಏನು ಮಾಡಿದ್ದಾರೆ? Possession of arms, licensed arms is not an offense at all. Arms Act alike.
That I will refrain from.
No Arms Act, no religious so and so.
My lords.
Three
license.
License ತಾನೆ. Unlicensed. That's not your case, unlicensed ಅಂತ. But ಮೂರು ಯಾಕೆ ಇಟ್ಕೊಂಡಿದ್ರಿ?
All licensed, my lords.
All licensed.
Not a case of any unlicensed weapons, no.
ಅಲ್ಲ ಎಲಿಫೆಂಟ್ ಕಾಟ ಏನಾರು ಇತ್ತ ಇಲ್ವಾ? ಸರಿ. All right.
A CD no ಅಮಾನತ್ ಆಗಿದೆ, my lords. That is at page number 241. What and all are present in the FSL with the exact annexures and all of that is present in the CD. Adu amanat agide, my lords. That is at 241. And
so all three licensed pistol.
Yes. I will refrain from the Arms Act.
Arms Act, then
religious institution, my lords. Under the cover of religious spaces, they have
in the earlier order which I have written concerning another pontiff, which this act had been invoked. That is confirmed by Supreme Court also. So that will not be there.
Yes.
And
my lords.
Division bench order
confirmed by Supreme Court as well.
Supreme Court has affirmed my order, so that I will not.
There are two
consideration ishte idralli POCSO and 376 I will consider.
Yes.
But Arms Act will not be there. IT Act and transmit ಮಾಡಿದಾರ 666E and 67A.
That they have he has asked her to share some photos, and he has also, in a very nude way, he has called her through WhatsApp, my lords.
Pontifa?
Yes.
ಅದು ಇದೆಯಾ ಇಲ್ಲಿ?
My lords, that is she has mentioned that in a few places, my lords. So that is the reason.
Not transmission, my lords. Transmission is where
transmission alla. You made video calls with nothing ಅಂತ ಹೇಳ್ತಾರೆ.
No, my lords, that's not a little point at which
he has also asked her to
which version of one of the 5 versions it should be there. Which version are they?
I don't know what versions they're talking about, my lords, but it is the same single version that she has narrated throughout.
Those three enactments definitely, the offences under those enactments definitely will go. This I will consider.
My lords, one aspect of.
Mugsbidli Tadi. Yes.
Thus, my lords, requesting that the bail may be cancelled, my lord, because he's out. He's out on bail.
So,
my lords, there are two other separate FIRs also against him.
Threatened the witnesses.
Threatened the witnesses. Then he has threatened the victim itself also through one named Manoj.
All right. They are registered murder crime. Victim has registered.
Victim itself, my lord. The second FIR also registered by the victim on 8/3/2024 that she had got a phone call stating that Manoj had told that the Swamiji had instructed him to say certain things to her. ವಿಚಾರಿಸ್ಕೊಳಕ್ಕೆ ಏನ್ ನಡೀತಾ ಇದೆ, ಯಾರು ಮಾಡಿರೋದು ಎತ್ತ ಅಂತ
ವಿಚಾರಣೆ ಮಾಡೋದು ಥ್ರೆಟನಿಂಗ್.
My lords, he had told that nobody can touch me. I am invincible ಅನ್ನೋದೆಲ್ಲ ಹೇಳಿದ್ದಾರೆ.
That is not convincible.
My lords, yes, that is, my lords, she's a 19-year-old girl.
That will consider. Bail cancellation ನೋಡೋಣ, but these three definitely I will quash. I have told you. Then remaining 376 and POCSO will consider whether it has to be sustained or not. We'll see.
Pray that this bail may be cancelled.
Bail also that I will see if there is really threatening of witnesses. See, bail generally ನಿಮಗೂ ಕಾನೂನು ಗೊತ್ತು. Once it is granted in rare circumstances, it is.
My lords, the trial court has been proactive in granting the bail. My lords, charge sheet ಅಲ್ಲಿ then there is so much material on record.
ಅಲ್ಲ, ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿದ್ಮೇಲೆ ಏನ್ ಬೇಲ್ ಯಾಕೆ ಕೊಡಬಾರ್ದು?
My lords,
only in exceptional circumstances.
My lords, she has given the
condition is that you should not threaten the witness.
No, my lords, she has given the complaint. She has not given the complaint for 7 years because she was scared of him, my lords. He is there several times. She has told that he has threatened her and her family that he will do away with the life.
Why did you go back to the pontiff again and again?
My lords, the parents were taking her to the mutt. It was not her on her instance she was going. She was only going with her parents, and it is not that she was ಅವರಾಗವರು ಒಂದು ರೂಮಿಗೆ ನಡ್ಕೊಂಡು ಹೋಗೋದಲ್ಲ. She has been instructed and she has been called to those places, and that is where the occurrence have taken place. It is not that she has gone.
We'll see. Yes, anything, sir? Nothing.
One aspect can I just point out? They were mentioning a lot about what they got through the phone. Well, it's page 21. Please notice which is the phone in question. Page 21.
iPhone.
The phone in question was her mother's phone. According to her, the calls were going to the mother.
Correct.
And then, my lords, page 39 is where she says, my mother's phone is not there. In an incident which took place, it is destroyed. Please notice 39. So with this being so, what is it that
is her own phone, victim's phone?
Adala, her complaint is the call was to the mother's phone. 21 ali specifically she gives the telephone number. Page 21 may be noticed, my lords. The number to which the calls were done. And that phone, according to her, in a fire was destroyed. So what is this relevance of saying that through that phone, a phone which is destroyed?
So according to you, tell me, everything is false, is it?
Not everything is false.
Something
Not everything is false, my lords.
Something is true.
My lords, to the extent.
So what is the
matter of trial? My lords, to the extent of saying she was going to the mutt, coming back, to that extent. But to say whether there's an act of rape, my lords, after 7 years, my lords, from what we get as a version, my respectful submission, my lords, it is not at all.
So sometimes the victims who are minors, who get, who have to face these circumstances, become tongue-tied because the societal problems that they would face.
2022 major. 2022, she becomes a major.
We'll consider that.
2024, after an FIR is registered against CW 6 and 7, you immediately give a complaint. And my lords, the two FIRs where they say, yes, my lords, 2 FIRs which they say threat was given, is stayed by this court. Both the matters are stayed by this court.
I myself stayed. Yes, we'll see. But reserved.
Obliged.
And one,
the answer, I'll come back after the bench, unless all of you have any problem. Idhar ildar naale. Whatever is there, ella naale. Unless specifically adjourned, bere ella naale barutte.
My lords.
18 and 19.
All right, ನಾಳೆ ಬರ್.
One last submission, my lords. Crime number 14 that they have registered against the witnesses, my lords, that B report, my lords, they have not challenged till today. So that
There's
is
no
considered to
sitting.
be a B
We
report, my
filed our
lords.
wakalat, there's no
All
sitting
their,
in the
my
court.
lords, all their contentions are based on
Not
that.
accepted.
So
Are
these,
based on
those
that.
are all incidental to the main matter. We will see. Yes. Raghavan sir. ಅದನ್ನ ನಾಳೆ ಆಗ್ಬೋದಾ? ಇಲ್ಲಾಂದ್ರೆ ನಾನು ಮುಗಿಸ್ಕೊಂಡ್ ಬರ್ತೀನಿ, ನೀವು ಇರ್ತೀರಾ ಅಂದ್ರೆ ನನಗೇನು ತೊಂದರೆ ಇಲ್ಲ. ಅದೇ ಪೂವೆ ಸರ್ ಅಂಡ್ ಹಾ 4:30 ಮುಗಿದ್ರೆ 4:30 4:45 ಬೆಂಚ್ ಮುಗಿದ್ರೆ can sit up to 6 o'clock and if you have no problem. Then whoever wants to be adjourned tomorrow ಬರುತ್ತೆ. ನರ್ಗುನ್ ಸರ್ ಇದ್ರಲ್ಲ ಅವ್ರದ್ದು ಅಷ್ಟೇ ನಾಳೆ ಬರುತ್ತೆ. Fruits and vegetables ನಾಳೆ.
My lords, serial number 16 also kindly have tomorrow. 16 also tomorrow, my lords.
16 ಯಾವುದು?
ಇನ್ನೊಂದು folks.
ಅದು ಎಲ್ಲಿ ಇವರು ನಾಳೆ? ಇಲ್ಲಾಂದ್ರೆ ಗಾಯ್ತಾರ ಅವರು? ಅವ್ರು ಜೆಟ್ ಲ್ಯಾಗ್ ಲಂಡನ್ ಇಂದ ಬಂದಿದ್ದಾರಂತೆ. ಆಯ್ತು, ನಿಮ್ ಕೊಲೀಗ್ ಇಟ್ಕೊಂಡು ನಾಳೆ ಮಾಡಿ, ತೊಂದರೆ ಇಲ್ಲ. ವಾಟ್ ಈಸ್ ದೇರ್ ಐ ವಿಲ್ ಹಿಯರ್, ಲೆಟ್ ಯುವರ್ ಕೊಲೀಗ್ ಬಿ ಹಿಯರ್, ಟುಮಾರೋ ವಿಲ್ ಟೇಕ್. ಕ್ರಿಮಿನಲ್ ಅಪೀಲ್ ಅದು? ಅಪೀಲ್ಸ್ ನಾಳೆ ಅಲ್ಲ, ಅಪೀಲ್ಸ್ ಇದ್ರೆ ಐ ಕಮ್ ಬ್ಯಾಕ್, ವಿಲ್ ಸಿ ಹೂಎವರ್ ಇಸ್ ದೇರ್ ವಿಲ್ ಸಿ. ಎಸ್.
pretty soon. Hey, ಬಂದ್ರು light.
AC ಬೇಡ AC ಬೇಡ ಅಲ್ಲೇ AC ಬೇಡ ಅದ್ರಲ್ಲಿ ಹಿಂದೆ ಇದೆ AC ಬೇಡ
Yes, sir. Whoever is ready. Nagesh sir इधर. Those clubbing matters.
ಅಲ್ಲ ಕ್ಲಬ್ಬಿಂಗ್ ಅಲ್ಲ
Pasha sir, ಯಾವುದು? Which one?
Same connected matter, my lord, 11.1 and 11.3, your lordship.
Yes, sir. Yes, sir.
My lord, we are not basically in the question of clubbing of cases. We are basically in the question which we have raised while placing reliance on the law laid down by the Supreme Court. Number one, with regard to the charges that are framed against the accused in the case. Number two, when the accused came to be put on trial in the case, 6 cases were there. What the learned trial judge has done is cut and paste carbon copy. That is also again it is covered by the law laid down by the Supreme Court. That is the second point. And there is no sentence at all passed in one of the cases. Andre, ultimately, if my lord were to feel what warrants is a remand, in addition to the point which my learned friend Mr. Nagendra.
So all these culminate
yes.
in a consequence of remand.
Otherwise, in addition, these points which I would be canvassing before your lordship, my lord, would be in addition to what my learned friend Mr. Nagendra Naik would be canvassing with regard to the clubbing.
All right.
But I think, my lord, it is 5:30 to be inhuman for me to request your lordship to hear us today.
Today, no, because I told that I'll come back, I came back.
Doesn't matter. My lord,
because division bench agidde ಈಗ.
It will be inhuman for me to request your lordship to sit and hear us because it may take some time.
No, it will take some time, not
now. It will certainly take some time. My lord, what I would suggest, subject to what my lord would say, now that my lord would be sitting in Dharwad, kindly give us a clear date in Dharwad.
ಆಯ್ತು, ಯಾವತ್ತು
And
ನೀವು ಹೇಳಿ.
ಅಲ್ಲಿ ಇಷ್ಟೊಂದು
ತೊಂದ್ರೆ ಇರಲ್ಲ.
work pressure subject to
ಒತ್ತಡ ಇರಲ್ಲ.
what Nagendra Naik would say and my other
I am
colleagues
ready. I was always
who are
saying that.
representing the other appellants in the connected matters would say, ಅಲ್ಲಿ ಇಷ್ಟೊಂದು ಪ್ರೆಷರ್ ಆಫ್ ವರ್ಕ್ ಇರೋದಿಲ್ಲ, ಕೂಲ್ ಆಗಿ ಕಾಮ್ ಆಗಿ ಮುಗಿಸ್ಬಿಡ್ಬೋದು ಅಂತ ನಾನು ಅನ್ಕೊಂಡೆ. ಇಟ್ ಇಸ್ ಸಬ್ಜೆಕ್ಟ್ ಟು ಮೈ ಲಾರ್ಡ್ಸ್ ಡೈರೆಕ್ಷನ್ಸ್.
Appeals requires some time.
ಅದೇ ಯಾವತ್ತು ಬೇಕು ಹೇಳಿದ್ರೆ ನಾನು ಐ ಅಡ್ಜಸ್ಟ್ ದಿ ವರ್ಕ್ ದಟ್ ವೇ ದೇರ್.
ಅಷ್ಟೇ. ಎನಿ ಟೈಮ್ ಡ್ಯೂರಿಂಗ್ ಈ ವೀಕ್ ಅಲ್ಲಿ ಬೇಡ ಅಂತ ಕಾಣುತ್ತೆ.
ಆಯ್ತು.
ಎನಿ ಟೈಮ್ ಡ್ಯೂರಿಂಗ್ ಫಸ್ಟ್ ವೀಕ್ ಮೇಲೆ ಎನಿ ಟೈಮ್
6, 7
ಎನಿ ಟೈಮ್ ಅಲ್ಲಿ. ಸೊ ದಟ್ ವಿ ಕ್ಯಾನ್ ಆಲ್ಸೋ
ಮುಗಿಸ್ಬಿಡೋಣ.
ಅವತ್ತು ಮುಗಿಸ್ಬಿಡೋಣ.
ಜಗದೀಶ್ ಸರ್ ನಿಮ್ಗೆ ಯಾವತ್ತಾಗುತ್ತೆ? ನೀವಿಲ್ವಾ ಇದರಲ್ಲಿ? ಇವರು ಎಸ್ ವೇರ್ ಆರ್ ಯು?
My lord, if possible tomorrow I may permitted to say about 10 minutes, my lord. My appeal will not be much. Physically I will appear.
You'll follow, you can come virtual appearance sir on the 6th. ಎಲ್ಲ ಒಟ್ಟಿಗೆ we'll take everything on 6th.
ಎಂತ ಆಗ್ಬೋದು?
I am permitted to appear through virtual.
10th Monday ಆಗದೇ ಇಲ್ಲ. ಬಿಕಾಸ್ ಅಲ್ಲೇನು ಒತ್ತಡ ಇಲ್ಲ ಅಲ್ಲ, ಸೋಮವಾರ 500 ಇದೆ ಅಲ್ಲೂ.
ಯಾತಕ್ಕೆ 10th ಕೇಳ್ತಾ ಇದಾರೆ ನಮ್ಮ ಸ್ನೇಹಿತರು ಅಂತಂದ್ರೆ 9th ಸಂಡೇ ನಾವು 9th ಈವ್ನಿಂಗ್ ಅಲ್ಲಿ ಬಂದು ತಂಗಿ 10th ಬೆಳಗ್ಗೆ
5ಕ್ಕೂ ರಜೆ ಇರಬೇಕು ನೋಡಿ. 5ಕ್ಕೆ ರಜೆ ಇದೆ, 6ಕ್ಕೆ ತಗೊಂಡ್ರೆ ಅಟ್ ಲೀಸ್ಟ್.
ಯಾವತ್ತು ಈಗ November 1st ರಜಾ ಇರೋದು Saturday. That is Saturday.
Doesn't matter. My lord may kindly give us any day.
No, I'll give because ಅಲ್ಲೇ pressure is less ಅಂತಿಲ್ಲ. Monday even there I have 500 cases.
ಪರವಾಗಿಲ್ಲ.
So
ಬೇಡ.
Mondays ಬೇಡ. 6th or 7th. 7th Friday I can give. ಅದು we should ಅದು ಮುಗಿಸ್ಬಿಡೋಣ ಅವತ್ತು. ಅಲ್ಲ, because one more thing is these files have to be sent there. It's huge. If you are referring to paper books. Oh, there are.
I have prepared a chart.
Then.
If my lord permits me, I shall just pass on.
Yes, sir.
I have prepared a chart of the evidence of witnesses.
Because huge bulk of paper books which have to be transported now. This is fine. This kind of chart idbitre namge
alla IO evidence cut and paste. IO evidence I can understand, my lord, the evidence of adu agalla. Ultimately, if my lord is persuaded to accept our submissions
on this issue,
this is impermissible in law.
It has to go back.
This is impermissible in law. We can cut short our submissions, my lord.
That's what it has to go back for that purpose.
Subject to what the learned public prosecutor would say and the.
No, issue. For that he has to come back. He has gone somewhere.
Barli. Yen tondre illa.
Yes.
No, all right. We will take our. We'll be there before your lordship.
7th. We'll keep it on 7th.
We'll be there. ಇನ್ನೊಂದು ಸಬ್ಮಿಷನ್ ಇನ್ನೊಂದಿದೆ, ಅದನ್ನು ಅವತ್ತೇ ಹಾಕೊಂಡ್ಬಿಟ್ರೆ ಸರಿ ಹೋಗುತ್ತೆ.
ಇದಲ್ವಾ?
ಚಿತ್ರದುರ್ಗ.
ಚಿತ್ರದುರ್ಗ ಅದು 7ನೇ ತಾರೀಕಿಗೆ ಹಾಕೋಣ. ಅಲ್ಲ, ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಅರ್ಜೆನ್ಸಿ ಅನ್ನೋದು ಆ ತರ ಏನಿಲ್ವಾ ಅದರಲ್ಲಿ?
ಇವತ್ತೇ ಮಾಡ್ತೀರಿ.
ಅಲ್ಲ, ತೊಂದ್ರೆ ಇಲ್ಲ. ಅದು ಅವರು ರೆಡಿ ಇದೆ. ಅದರ್ ಸೈಡ್ ಆಲ್ಸೋ ರೆಡಿ. ನಾಳೆ ಮಾಡ್ತೀನಿ ಅಂದ್ರೆ ಅವರಾದ್ರೆ
7th ಹಾಕೊಂಡ್ಬೋಣ.
ಅದು 7th.
ಅದು ಹೆಚ್ಚಿಗೆ ಹೊತ್ತಾಗೋದಿಲ್ಲ. I think if my learned friend in his fairness, my lord, were to say yes, this order has got to be set aside, in 2 minutes it will be over.
In view of the earlier finding.
ಅದಲ್ಲ, ಇದು ಕಾಗ್ನಿಸನ್ಸ್ ಏನ್ ಬರೆದಿದ್ದಾರೆ ಅಂದ್ರೆ ಕಾಗ್ನಿಸನ್ಸ್ ಟೇಕನ್ ಇಶ್ಯೂ ಸಮನ್ಸ್ ಅಂತ ಅಲ್ಲೇ ನಿಂತು ಹೋಗುತ್ತೆ ಸಾಕು. ಅಂಡ್ ಎನಿ ನಂಬರ್ ಆಫ್ ಜಡ್ಮೆಂಟ್ಸ್ ಅಂಡ್ ಪ್ರೊನೌನ್ಸ್ಮೆಂಟ್ ಆಫ್ ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್ಸ್ ಅಂಡ್ ಆಲ್ಸೋ ಆಫ್ ದಿ ಸುಪ್ರೀಂ ಕೋರ್ಟ್, ಅದು ಏನು ವಿತೌಟ್ ಗೋಯಿಂಗ್ ಇನ್ ಟು ದಿ ಮೆರಿಟ್ಸ್ ಆಫ್ ದಿ ಮ್ಯಾಟರ್. ಪ್ರಾಬ್ಲಿ ಐ ಮೇ ಹ್ಯಾವ್ ಟು ಟೇಕ್ ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್ ಆನ್ ದಿ ಮೆರಿಟ್ಸ್ ಆಫ್ ದಿ ಮ್ಯಾಟರ್ ಆಸ್ ವೆಲ್.
ಅದಕ್ಕೆ we'll take it on 7th only. 7th we'll start at ಅಲ್ಲಿ preliminary work ಮುಗಿಸ್ಬಿಟ್ಟು by 11:30 I'll start. Please. And we'll finish it off.
Please.
Yes. Madam Prasanna Kumar on 7th. Jagdish sir. ಇಲ್ಲ ಡೇಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಅಂತ. ಎಸ್ ಮೇಡಮ್.
Yes. Yes, Raghavan, sir.
I feel very embarrassed, my lord.
Sorry, my
I
lord,
told
in
my
serial
learned
number
friend-
16.
Interim order will continue.
Grateful.
I told my learned friend, my lord.
Madam, adjourn, ಅದು ಯಾವ್ದು ಆಯ್ತು ಈಗ 9, 10, 11, 12. 9, 10, 11, 12, 16. Interim orders ಯಾವ್ದು ಎಲ್ಲೆಲ್ಲಿದೆ ಅಂತ ಕಂಟಿನ್ಯೂ ಮಾಡೋದು.
I told my learned friend, Mr. Nagesh, my lord, if I now insist that my matter must be taken up, I will look like a villain and he is an angel.
Whatever insistence, that will never happen, sir.
No, my lord,
You're always a hero, sir.
No,
What is
but
this
still,
villain?
5:15, my lord, after such a long day to.
No, because of the bench and
I know,
coming and going.
but no,
Yes.
we know, my lord. And ultimately, my lord, we also have to. So whenever your lordships are.
And
Tomorrow,
Madhyana, there was one Supreme Court matter which I had to. That's why I cut short my lunch also and came in.
So is
Because
the
the
lordship
bench
sitting tomorrow morning, my lord?
tomorrow afternoon.
Tomorrow afternoon.
Morning ಇಲ್ಲ tomorrow afternoon. ಇಲ್ಲಾಂದ್ರೆ ಇನ್ನೊಂದು ಡೇಟ್ ಕೊಡ್ತೀನಿ.
ಇನ್ನೊಂದು ಯಾವ ತರ ನಾವು ಬೇಕಾದ್ರೆ ನನಗೂ ಇದೇ ಫಾರ್ಮುಲಾ ಅಡಾಪ್ಟ್ ಮಾಡಿದ್ರೆ ನಾನು ಬರ್ತೀನಿ ಧಾರವಾಡಕ್ಕೆ.
ಆಯ್ತು, 14th
ಕೊಟ್ಬಿಟ್ಟು
ಹಾಕೋಣ.
ನಾನು ಅರ್ಧ ದಿನ ಮುಗಿಸ್ಬಿಡ್ತೀನಿ.
14th.
ಸ್ವಲ್ಪ ಬೇಗ reason, there is reason is only this one. Now the extension granted.
Oh,
by
this
the
KD Bidal.
ಹೌದು.
Yes, then
Extension granted by-
this will take one ನಿಮಿಷ. I'll
extension granted
No,
by
no,
KDB is only for 2 years. The plan is sort of
31st. 31st Friday, next Friday.
ತಾವು ಇರ್ತೀರಿ
ಅಲ್ಲ ಅಲ್ಲಿ.
ಅಲ್ಲಿ
ಅಲ್ಲಿ. You can appear online also.
whatever, but the records must come from here.
That we will see. If I give a date, it will definitely come.
Very well. Then
Yes.
But I am obliged. I am obliged. Either I will come personally or do it through VC.
Anything, sir.
I will.
We have heard you from Manhattan.
I know.
So
Your lordships are kind, my lord. Your lordships
no,
are
no,
very kind.
just in the lighter way. Because
I know. But at this point of time in the day, after long day, that your lordships are able to have this sense of
Yes.
humor and.
That's right.
Is,
And I've heard you from Manhattan.
I know.
Not a problem here at all.
Yes, my lord. Yes.
Yes.
I'll be there.
Yes. So we'll take it on. We'll take it as 31st.
31st.
Yes.
31st, would
What Agatha?
Please, no.
Povai, sir.
Yes. 31st, would it be in the morning itself or shall we come at 2:30?
Morning.
Morning.
31st. You come, sir. 31st, what I'll do is 11:30 or 12 o'clock, I'll wind up all the Dharwad work.
Yes.
In those days, I'll sit at 10 o'clock itself and finish off the Dharwad work there. And 11:30 or 12 o'clock, will finish this.
Great. Very great.
That shouldn't be a problem.
Yes. Great.
Yes.
Great.
Interim order may be extended.
Interim order, whatever is, that will continue. Don't it? Yes.
Great.
That, so it is 31st.
31st. Yes.
Please.
My lords, item number 19, my lords, is it for tomorrow, my lords, Mr.
19 ನಾಳೆ ಹೇಳಿದೀವಲ್ಲ?
Yes, my lords.
18 and 19 tomorrow ಅಂತ already have indicated. It will come tomorrow. Tomorrow 2:30.
Oblige, my lords.
Lordship, serial number 21 regarding KDB matter, Nargun sir is
ಯಾವ್ದು?
senior counsel Nargun, Queen City matter for tomorrow.
Fruits and vegetables. Fruits and vegetables.
They have to complete their argument in that matter, my lords.
Yes, yes. Innu so many fruits are to be referred to. What, sir?
Tomorrow.
ನಾಳೆ. That will be tomorrow. That will be tomorrow. ಪ್ರಕಾಶ್ ನಿಮ್ದು ನಾಳೆ.
Please.
ನಾಳೆ. ಮೇಡಮ್ ಅದು ಪ್ರಕಾಶ್ ಯಾವ್ದು 20 ಮಿಕ್ಕಿದೆಲ್ಲ ಫರ್ದರ್ ಯಾವ ಡೇಟ್ ಕೊಟ್ಟಿದ್ದೀನಿ ನಾಳೆ. ಒಂದು ನಿಮಿಷ ಹೇಳ್ಬಿಡ್ತೀನಿ ತಾಳಿ. ಅಲ್ಲ ಬೇಕಪ್ಪ ಮೇಡಮ್ ಒಂದು ನಿಮಿಷ. ಮೇಡಮ್ ಇದು 22 and 22.1 ಬೇಕಪ್ಪ ಮೇಡಮ್. 22 and 22.1 heard the learned counsel for the learned senior counsel Sajan Povaya appearing for the petitioner and the learned senior counsel KG Raghavan representing the respondent. Respondent number 2. List the matter on 31st for further hearing. Interim order subsisting will continue till the next date of hearing. Advocate? ಇದರಲ್ಲಿದ್ದಾರಾ? Oh, and the learned advocate general appearing for the first respondent board. ಅದು ಮಾಡಿ. It is on 31st. Interim order subsisting will continue to the next date of hearing. Now 21, 21.1 tomorrow.
Allowed in 21 one submission. We have filed our NOC, our name is not.
registry to print the name of, registry to print the name of BB Patil in place of HL Pradeep Kumar. ಅದು ನಾಳೆಗೆ ಆಗಿರಲ್ಲ ಬಟ್ ಬಂದ್ಬಿಡಿ. ಎಸ್ ಆಮೇಲೆ 20 ಪ್ರಕಾಶ್ ನಾಳೆಗ ಅವ್ರ ದೇವದಾಸನ ಸಬ್ಮಿಟ್ ಮಾಡ್ತೀನಿ ಇದು ನಾಳೆಗೆ ಹಾಕಿರ್ತೀನಿ. ಇದು 20 again tomorrow ಮೇಡಮ್. ಆಮೇಲೆ 18, 19 tomorrow ಮೇಡಮ್. ಆಮೇಲೆ 17 ಅಡ್ಜನ್ ಆಗಿದೆ. 16.1 it is on 7th, list on 7th for further hearing. Interim order heard the learned senior counsel C.V. Nagesh appearing for the petitioner and learned additional SPP. List the matter on 7th for further hearing. Interim order subsisting will continue to the next date of hearing. ಮಿಕ್ಕಿದ 14 ಅಲ್ಲಿ ಅಡ್ಜನ್ ಆಗಿದೆ. ಇನ್ಯಾವ್ದು ಉಳಿದಿದೆ ಮೇಡಮ್? ಕ್ರಿಮಿನಲ್ ಅಪೀಲ್ಸ್ ಅದು ಕಾಮನ್ ಆರ್ಡರ್ ಮೇಡಮ್. 9, 10, 11 ಕಾಮನ್ ಆರ್ಡರ್. ಲಿಸ್ಟ್ ದ ಮ್ಯಾಟರ್ ಆನ್ 7th. ಇಂಟರಿಮ್ ಆರ್ಡರ್ಸ್ ಅದ್ರಲ್ಲೇನಿಲ್ಲ. ಇದು ಅಪೀಲ್ಸ್ ಅಲ್ಲಿ ಇಟ್ಬಿಡಿ. ಎಲ್ಲ ಆಯ್ತಲ್ಲ ಅಷ್ಟೇ. We'll see you tomorrow.